Persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5314. Michael Abramowitz in his official capacity as Director of Voice of America et al. Versus Kari Lake in her official capacity as Senior Advisor to the Acting CEO of the United States Agency for Global Media et al. Appellants. Ms. Hedges for the appellants, Mr. Schultz for the appellees.
Good morning, counsel. Ms. Hedges, please proceed when you're ready.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Elizabeth Hedges on behalf of the United States. I would like to reserve 4 minutes for rebuttal. In Elgin versus Department of the Treasury, the Supreme Court held that a challenge to removal is precisely the type of personnel action regularly adjudicated by the MSPB and the Federal Circuit within the Civil Service Reform Act scheme. There's no dispute in this case that the Voice of America Director Michael Abramowitz is an inferior executive officer to whom the CSRA would generally apply. And there's no dispute that he's challenging his removal from that office. But the district court held that it had jurisdiction over the director's challenge to his removal, even though the CSRA provides the exclusive remedial scheme for claims within its scope. That decision was incorrect, and the court should reverse. The parties agree that under Thunder Basin's two-step framework, the CSRA provides the exclusive avenue for suit to a plaintiff whose claims fall within its scope. But the plaintiffs argue that this claim is collateral and not the type that Congress intended to channel because the government raises a structural constitutional challenge to the removal restriction in Section 6205E1. But in Elgin, the Supreme Court rejected an exception to CSRA exclusivity for facial or as-applied constitutional challenges to federal statutes. The availability of administrative and judicial review under the CSRA generally turns on the type of civil service employee and the type of adverse employment action at issue. That's the opinion in Elgin at page 12. It does not turn.
Ms. Hedges, that what we're trying to ascertain here is congressional intent. And here we have a very specific statute that Congress passed to preserve the independence of the Voice of America. And Congress passed a statute that said, in order to remove someone like Mr. Abramowitz, you have to get the approval of this board, a special board. And that board didn't have a quorum, and his removal was instigated without that type of approval. And it seems to me that if you're looking at the type of claim that Mr. Abramowitz is bringing and that statutory backdrop, it's hard to say that Congress would have intended that that claim be channeled, because the purpose of that statute was to ensure that before the head of the Voice of America could be removed, there had to be approval. And if you channel this, he will be removed without approval, because the MSPB has no ability to enter an injunction. There would be a long, lengthy process before the merits could be addressed. And so it just seems very hard when you look at the overarching purpose of Thunder Basin and our analysis here to say that Congress would have intended that this claim be channeled.
So, Your Honor, I respectfully disagree with that. The fact that Congress put a substantive removal restriction in the statute doesn't say anything about where those claims challenging the removal allegedly in violation of that restriction should be heard in the first instance. And in Elgin, and also followed by this court in AFGE in 2019, both of those courts recognized that meaningful judicial review is not unavailable just because a claim is channeled and then goes to the federal circuit.
I'm trying to focus on the particular statutory backdrop of this case, which is this statute that was specifically passed to preserve independence and prevent the removal of the director of the Voice of America without this approval in order to preserve independence. And it seems that the purpose of that statute would be vitiated if you channel, because if you channel to the MSPB, there can be no interim relief. He is removed without the approval of the board, and that lasts for a long period of time. before that can be resolved before the MSPB. Can you focus on this particular statute?
Yes, Your Honor. So this particular statute does not say where a challenge to removal
It
under.
doesn't say it one way or the other. And so we're trying to ascertain congressional intent.
Right, Your Honor. And so it doesn't deviate from the scheme in the CSRA that provides that for this type of employee making this type of challenge, it gets channeled. And something I would point out is that, as this court noted in AFGE, even if a claim or a claimant might never be able to get certain types of relief or review, that doesn't mean a claim doesn't get channeled as long as it's eventually able to get judicial review in a forum like the Federal Circuit.
No, I
So
understand all that. I'm just trying to focus on this particular statute. And is there any clue that Congress would have wanted this channeled?
the fact that Congress didn't provide a specific remedial scheme for these types of challenges. I mean, if you look at the type of relief that Mr. Abramowitz is seeking, he could seek reinstatement before the MSPB. And I understand that there would be a period of time before that's adjudicated, but that's the case as a general default matter in any litigation. Preliminary interim relief is the exception, or interim relief of any kind is the exception. So the fact that a process would need to take place before he gets a final adjudication doesn't change the default system that Congress did not alter in Title 22 when it enacted the substantive removal restriction.
Ms. Hedges, if the same claim, type of claim that was raised in Axon or in free enterprise were presented by the MSPB, like if Congress passed a statute and said for cause removal of everybody there, and Abramowitz wanted to raise a challenge saying, I can't be subjected to that because it's not sufficiently accountable to the executive. Do you read Elgin because of its breadth as supporting a different result there, notwithstanding Axon and free enterprise?
Your Honor, I read Axon and Elgin as consistent. And if we had a case where Mr. Abramowitz was challenging the constitutionality of the MSPB process itself, we would be in a world that looks a lot more like Axon. But the court in Axon expressly explained why that was a different type of injury. It was an almost unique circumstance where the plaintiffs were challenging the constitutionality of the very process through which their grievances would ordinarily be channeled.
Just to be clear, in your view, in that situation, Axon, free enterprise would say that, no, those claims don't get challenged, notwithstanding Elgin.
And when you say those claims, Your Honor, I just want to make sure I understand what you mean.
Claims like the claims in each of those cases, if the law and the facts were different in terms of the composition of the MSPB. That it was like in Axon, the complaint was that the ALJs were insulated from presidential supervision by for cause protections, right?
Right, it's that they were unaccountable.
Yeah, they were unaccountable. And in free enterprise, it was that there was not only for cause protection, but there were two layers. So all I'm saying is if there was that kind of claim, the broad wording of Elgin doesn't mean it would come out differently from how those cases came out.
So if I'm understanding correctly, I don't think Elgin would come out any differently now than it did before Axon. And I think that
But if the MSPB, let's say, the members had the same removal protections that the ALJs in Axon had, then it would come out differently because Axon.
it might, Your Honor, but I don't know that it would be because of Axon, because again, I think it would depend on the type of claim being brought. So the court's analysis.
But if the claim were a claim, I can't be subjected to that because it violates the separation of powers.
It might be, Your Honor. That's not the case we have here.
No, I understand. I'm trying to understand the logic of your position. So do you have an answer to that question? I thought your answer was, well, what is your answer?
I think that if Mr. Abramowitz were saying, I can't be subjected to the MSPB process because whatever it may be, they're unaccountable, they're not sufficiently in check by another authority, then we would have a case that looks more like Axon. And so I assume if the Supreme Court had that case, they would look at the facts of that case, but it would look different from Elgin. It would look more like Axon, and it would be very different from what we have here.
So This, as you pointed out in the briefing, the shoe is on the other foot here in the sense that the Article 2 claim is being made by the government rather than by the plaintiff. But the plaintiff is also bringing a separation of powers sort of assertion that Congress has the authority to impose this removal regime, constitutional authority to do that, consistent with free enterprise, Axon, whatever cases. Is the fact that the same issue, the same kind of question about decision maker and the constitutionality of the decision maker is presented, doesn't that at least indicate that this is beyond the expertise of the MSPB, just as it was beyond the expertise of the administrative bodies in Axon and free enterprise?
No, Your Honor. And I would again point out that in AFGE and in Elgin, this court and the Supreme Court respectively addressed this issue of what does this expertise inquiry require? And all it requires is that the MSPB's expertise may be brought to bear on these types of claims. And I'm paraphrasing, but because I don't have the exact text in front of me, but may be brought to bear. It's not that in this every case, the MSPB's expertise is necessarily required in order to reach the constitutional issue. And an example would be in Elgin. If you look at, I believe it's the last few pages of the majority opinion in Elgin, the court is talking about what types of threshold issues might come up in these types of cases. It doesn't say that this claimant's claim necessarily raises those threshold issues over which the adjudicative body would have expertise. It says these are the types of issues that could come up. The agency's expertise could be brought to bear. It's not essential. That's the word that the court used in AFGE. It's not essential that it be brought to bear in every case in order for that inquiry to be satisfied.
What expertise are you imagining on this threshold question of whether a lawful termination decision was even made, a structurally valid termination decision was made?
So I have, I think, two responses. My first response would be, again, it's not necessary that a particular threshold question be brought up in this case that the MSPB would have to adjudicate. But my second point would be there are some assertions about the interpretation of the statute in the plaintiff's briefing in this matter that could be brought to the MSPB, and the MSPB might have a view on it.
Can you be more specific? I'm not sure what you're talking about.
So, for example, they make an assertion that the CEO is the entity that will make the recommendation for removal, and then the advisory board approves the removal. Now, I'm not saying that that's necessarily wrong, but it's not what the statute says. The statutory text we're dealing with very clearly says only upon the approval of the advisory board can the Voice of America director be removed. And then they make some allusions to past Supreme Court case law based on what they perceive to be an analogy between an implication of the statute and other statutory schemes at the Supreme Court.
Is that at all determinative here?
So, Your Honor, I think the broader point I'm trying to make,
because I gather there's no dispute that the statute requires board approval, or if by 5, unilateral action, and that did not occur. So there's not. The government isn't defending that statute was that 6205E was fulfilled.
It's correct. We are not disputing that the statutory mechanism of advisory board approval did not occur here. And so, again, I think the important thing to keep in mind is under Elgin, the question is not, is there a threshold issue in this case that the MSPB could deal with before it gets to the constitutional issue? The question is this the type of claim that could raise those types of potentially those types of threshold issues?
Is this the type of claim? At what level of generality are you describing the type of claim? Are you just saying it's a reinstatement? Or are you saying something about the particulars of this case that make it the type of claim as to which the expertise could be brought to bear?
I'm saying it's a challenge to his removal in alleged violation of a substantive statute. And that is the type of claim that, as the court said in Elgin, that this is the type of claim, a removal claim that is regularly adjudicated. And yes, we can then look at, in more granular detail, the collateralism inquiry, the expertise inquiry, the meaningful judicial review inquiry. But what the courts have said is that review ultimately in the federal circuit satisfies that meaningful review as long as it's available, even if you raise a constitutional claim.
So your view is any removal claim where the assertion is the removal is unlawful, that goes to the MSPB per Elgin.
So I'm not purporting to speak regarding any possible claim, Your Honor, and I don't want to be heard to be saying that. What I'm saying is that this claim, there's nothing about this claim, especially after Elgin, which dealt with this issue of a constitutional dimension and rejected an exception to channeling, especially after that decision. There's nothing about this claim that takes it out of the type of claim that should be channeled.
What about
Except
the
that the
statute?
constitutional issue, it had to do with the substantive grounds of the removal.
It had to do with a violation of the Selective Service Act, I believe, in Elgin.
Right. And so the claim was that the basis for the removal was unlawful.
Right. So the man was making a substantive challenge to the terms of the statute and saying it was discriminatory. So of course, here we don't have a discrimination claim. We have a claim that that his removal was in violation of a different substantive statute, but I don't see anything in Elgin that would move the needle there.
So in terms, though, of both collateral, the inquiries under Thunder Basin, whether it's collateral and whether it's within the agency's expertise, I read 6205E not to address an employee's interest in his tenure in office as such, but really as a means to guarantee the professional integrity of the government-run broadcasters. And if that's right, then isn't it collateral in the same way, for example, that the process, the issue raised in Axon was collateral because nothing that the MSPB does really goes to that. The MSPB has no expertise in the professional integrity of government-run broadcast, and indeed, it does it? I mean, what's your response to that understanding of 6205E and Congress's purpose in enacting it?
So, Your Honor, I think that making that analogy to Axon requires looking at the statute in far too broad a level of generality, among other things, because the key factor in Axon was what the court said was a here and now injury of subjection to an unconstitutional process that cannot be remedied later, because later you're done with the process.
Right.
This is different because later, if Mr. Abramowitz went to the MSPB, he could seek reinstatement. He could seek back pay. He could seek these types of relief. And that's something also that
Right. But my question was, well, what about, so can the MSPB enter any kind of preliminary or immediate relief, TRO, preliminary injunction?
Not that I'm aware, Your Honor, although I don't know the exhaustive list. I know they can do reinstatement. I know they can do back pay. I believe they might be able to do fees in some circumstances.
So if, and you may disagree with this, but just go with me for the purposes of understanding your position. If 6205E is intended to prevent interference by, partisan actors wanting to use the Voice of America as a mouthpiece rather than as objective journalism and having the professional integrity that the Congress was trying to protect, talks about trying to protect in enacting 6205E. If that's the interest, then if somebody is removed in violation of the protections that Congress added in 6205E, it seems important that there be swift response to that, precisely to protect the reputation and independence of the broadcasters. And so it does seem like there's a harm that can't be undone if the nature of the broadcasters is changed and the listenership says, oh, we don't trust this anymore. And, the delay actually, it does arguably have a parallel collateral nature and harm that's not remediable by the ordinary relief that the administrative process is capable of affording.
So, Your Honor, I have a couple responses to that. I think one of the key words that Your Honor just said was arguably. So there's nothing in this record that shows that the assertions that the plaintiffs make of some harm to the reputation is actually something that has occurred or is going to occur. But I think the more fundamental point is that the statute doesn't say anything about that. It doesn't say, for example, because Congress thinks that if this individual is removed, there's going to be irreparable harm to the VOA's reputation, therefore it must not be channeled. Like, there's no language in the statute that says this is the type of claim that can't be channeled. It just says here's a substantive removal restriction. So that would be my fundamental response.
The CSRA doesn't even say it has to be channeled. We're dealing with implications in both situations. And so I guess the question is there enough here to think, you know, this structural safeguard, the purpose of it supports an intent not to channel as distinct from the kinds of claims that were channeled in Elgin. And I don't think it's constitutional, non-constitutional. I think it's really about, you know, just what the nature of the claim is and what the nature of the Congress's project is.
Well, I don't agree with that, Your Honor, because setting aside the points I just made, I think you could say a similar thing about any important substantive goal that Congress has put into substantive statute that is allegedly being transgressed by a removal or an adverse employment action. So just because Congress has enacted a substantive statute, presumably many of those statutes are very substantively important. The Federal Labor Relations Act, which I believe is at issue in AFGE. These are all very important substantive statutes, but that doesn't say.
This statute I think is different, and I'd like you to address this. And it's different from Elgin in that this is a statute about removal. It says you cannot remove unless the advisory board approves. And so because it is so specifically about removal, it seems really different in kind from these other statutes. And the purpose of the statute is to ensure, you know, the independence of the Voice of America. But the fact that Congress has specifically said you can't remove without, you know, this approval means that you can't get meaningful review of that statutory violation if in the interim Mr. Abramowitz is removed without that approval, and then it takes years to get through the MSPB. And that is how this is different, I think, or at least one way in which this is different from Elgin. Elgin is not about a removal. And the purpose of that was discrimination, et cetera. This is, which is more, I think, in line with, you know, normal discrimination, employment cases. This is specifically about removal. Congress had an intent about how removal can take place. And it would defeat the purpose of the statute to channel this because the MSPB cannot grant preliminary injunctions or interim relief. And he will be removed in violation of the statute for years. And therefore, it just doesn't seem like Congress could have intended that this be channeled because it defeats the entire purpose of the statute.
Again, Your Honor, I think, you know, respectfully, I think if Congress had wanted to make that purpose plain, it could have done so much more easily than it has in this statute, which again, just sets up a substantive restriction. And I think even you could say in the discrimination cases, the discrimination statutes or the discrimination case law that the Supreme Court has promulgated under the constitutional provisions that were at issue in Elgin, those are designed to protect people's substantive rights, and for the duration of any litigation, those rights are allegedly being harmed.
Different kind of statute. It's not about removal, which is what the statute is about.
It is designed to prevent a different type of action or alleged harm, but that doesn't change the fact that Congress hasn't said.
Let's look at it from another perspective. Like, the question is meaningful review. Can you articulate what is the meaningful review if this gets channeled? Mr. Abramowitz gets removed. It gets channeled. It takes several years. What's the meaningful review?
So the meaningful review, so first of all, the MSPB will be able to review his claim. The meaningful judicial review in an Article 3 court could take place before the federal circuit, because if Mr. Abramowitz were to lose in front of the MSPB, he could go to the federal circuit. And the courts have said, the Supreme Court has said, even if you get review at the end of the process.
It's really about the timing, right? Because this removal statute says you can't remove him without the approval. And in effect, you will have removed him without the approval for 5 years or whatever it is.
Your Honor, I'm not
Why would Congress have wanted that?
I'm not seeing in the statute or the case law that the timing moves the
Axon
needle.
suggests that it definitely does.
Axon said that because the process itself that you're going to go through is the injury, that's categorically not something you can remedy later. But
Axon suggests that timing is a factor, maybe not the dispositive factor, but I mean, we are looking at somewhat different, factual scenarios and trying to ascertain ultimately congressional intent. And that's why I'm very focused on this statute and Congress's intent with this statute. And I'm just not hearing any response from you that persuades me that Congress could possibly have intended that this be channeled such that the whole purpose of the statute is defeated.
Your Honor, my short version of my response is that Congress didn't say that there's a special way we want this
adjudicated. All of these
adjudicated.
cases, they never explicitly say, we're trying to ascertain congressional intent without their explicit saying we want it channeled or we don't want it channeled. They haven't said in any of these cases what they want.
But again, I think that's why Axon is such an unusual case, is because the court went to great lengths to explain why that injury was unique and why it was different from a
Why
case.
isn't this one unique in a different way?
Because
It's a statute about removal.
but Mr. Abramowitz is not challenging the process by which that's getting adjudicated. He's challenging the fact that
I don't understand.
I'm just drawing a distinction with Axon. I believe I'm answering the question, how is this different? And my only point was Mr. Abramowitz's problem that he's asserting is that he doesn't want to be removed. He's not saying.
He's asserting specifically that he was removed in violation of 6205E. So the claim is a 6205E claim. And, you're saying that all he wants is to be put back. Let's say he prevails before the MSPB, which it seems like he likely would, and the government decides not to appeal, then he has no ability, no judicial forum for his claim, right?
If I understand you correctly, if he prevailed before the MSPB, he could get potentially everything he's asking for.
Well, he would get back in the job, but he wouldn't get any opinion saying that 6205E is consistent with Article 2, that defeats your merits defense to his termination without the 6205E process, right? You would still, the government would say, hey, no judgment against us on this. Next time, we're going to do it again.
Your Honor, I don't think that is the right way to think about this, because if he prevailed in front of the MSPB, he would have probably everything he's seeking here. And that's the question.
He would get back in the job with the same sort of Damocles hanging over him that Congress sought to, hold a little more securely from dropping by enacting 6205E. So then the other heads of the, Radio Free Asia, Middle East Broadcasting would be thinking, gosh, the professional integrity of the broadcasting activity is not actually protected by that congressional statute the way I thought, because we don't even have a judicial decision holding that it's constitutional, consistent with free enterprise and Morrison and Axon. The government is still free to, presumably might still consider itself free to violate 6205E because of its position taken in this litigation that it's constitutionally invalid.
Well, Your Honor, I think that would get us, analyzing it through that lens would get us afield from what is presented in this case.
You're insisting to answer to Judge Pan that there is judicial relief. We're not in Webster versus Stowe territory because there is judicial relief, and that's that's important to Elgin's analysis. But I'm just saying here, if he gets reinstatement, there's not going to be a chance that he wouldn't be able to seek a ruling on the constitutional question.
I mean,
Maybe it doesn't matter.
I think, well, a couple of responses. I think the MSPB could in theory issue a ruling on the constitutional question. As far as some potential future fear among grantees or heads of networks, that is not a claim that is presented in this appeal, because all that's at issue is the removal itself.
What about Mr. Abramowitz himself? He prevails before the MSPB, goes back to work, and himself is thinking, Congress enacted this law to protect the integrity of my enterprise, but the government has taken the position it's unconstitutional, it's not going to follow it. What protection does this person, so he hasn't really obtained full relief.
So the courts have not predicated the determination of whether judicial review is meaningful on whether some future claim might or might not.
Well, then look at the nature of the claim that's being brought, and whether it's collateral and whether it's in the expertise of the agency, and also whether it gets reviewed. And so to me, there is a way of thinking about this statute in which it's collateral and not in the expertise, and maybe even, although I do think that's a closer issue, maybe even not meaningfully subject to judicial review.
So, Your Honor, I think we have to deal with the claim as pled and as ruled on. The claim is, I was removed in violation of a statute. I want my job back. I don't want to be removed. And so,
in violation of this statute, which is really about protecting the journalistic integrity of Voice of America and the Associated Broadcast. I would love to hear your constitutional, your argument that this statute is not constitutional, because it seems to me, if you have a multi-member body that every member of which is removable at will, and even if it's, in a separate, like Key Club is separate from the SEC, the court, the special division of the court in Morrison was separate from the Attorney General. I don't see why there isn't plenty of precedent to have the sort of, the head for purposes of appointment and removal be different from the head for purposes of supervision. And so I'm just not really sure that under existing law, you have a strong argument that this statute's unconstitutional, but I'd love to hear your argument on that.
right, Your Honor. So in SILA law, the Supreme Court said that there's two restrictions on removal authority that our precedents have recognized. It's for a multi-member body of experts, and it's for inferior officers with limited policymaking and administrative authority. There's no serious argument in this case that either of those applies to Mr. Abramowitz. And so the argument is, I think, being made on the other side that, well, because this type of restriction might impose less of a burden on removal than other restrictions that have been upheld, therefore it's okay. But the fact remains, and I believe the court said this in SILA law as well, a case like Free Enterprise Fund or any of the Supreme Court's other cases is not a standing invitation to create new exceptions. And several times in the last decade or so, the Supreme Court has reiterated these are the two exceptions, and we're not going to go beyond that. And so what we have here is we have the CEO, who's the head of the agency, who the Voice of America director reports to, does not have the authority to remove him. Instead, Congress has set up an independent body. The statute says that the advisory board exists as an independent entity within the executive branch under 5 U.S.C. 104, and that independent body is given final say over the removal. I haven't seen.
I'm sorry, what's wrong with that? Because it's a head of department. Under the case law, a head of department can remove an inferior officer, which Mr. Abramowitz is. The advisory board is a head of department, and it has authority to remove Mr. Abramowitz. Why is that not just a straightforward application of the law that's come before? it's a head of department,
So-
has authority to remove the inferior officer. If that's allowed.
It's not the head of the department where Mr. Abramowitz is employed. That would be the CEO by statute under.
I mean, it can be because you're allowed to have interbranch heads of departments and appointments, and it can be, and it's been given all of this authority to, it has to not only, it's not just the removal authority, it has to consult with the CEO, it has to do all these other things with the CEO. Like, why isn't it the head of the department?
Well, Your Honor, I don't think even the plaintiffs are arguing it's the head of the USAGM. That's,
I'm sorry.
I just well, it's a head of department that has authority to remove him.
under the statute, but that's the problem is that Congress, there's no precedent that I've seen in their papers, in my research, anywhere for saying we're going to diffuse removal power between the head of the department where you work and the head of this independent entity that isn't even in the hierarchy. All the cases they cite that, as far as I was able to
But
tell.
there's authority that says interbranch appointment authority is fine, like Morrison versus Olson, other ones, like there's no problem with that interbranch aspect of this.
Well, Your Honor, I mean, so Morrison didn't bless a scheme like this.
No, but it stands for the proposition that interbranch appointment authority is okay.
Well, Your Honor, I mean, so I disagree with reading Morrison that broadly, but setting that
I'm
aside.
just saying that I don't think that there is authority for your position because free enterprise is very different and that's what you're relying on. And the one layer of at-will removal from the president and the fact that this is a department head seems all in line with case law.
I think it requires overreading and extrapolating too much from those cases because, there's no dispute that none of those cases decided a structure like this. The question is this more like those cases or is this more like something we've never seen that Article
On that, can I
2?
just ask this question on which category it falls into? I know that you think that that the board would be the head of the wrong department in a way because you think it's located in the wrong place. It's not in the direct line in the way that you think would be required. But do you dispute that the board qualifies as the head of a department? Again, might not be the right head of department.
So just to clarify, so first I'll answer your question. We're not disputing that they could be viewed as head of a department.
Okay.
And just to clarify my position, I'm not saying that necessarily, even if they were in the department, that necessarily the removal restriction would be constitutional. That would be a question that's
Sure.
not in front of us. But
Yep.
to your point, I don't dispute that they could be viewed as a head of a department.
I just want to make sure that that's true. And then I know that you still have your argument that even if they are the head of a department, it's still the wrong department or the wrong head.
That's
It's
right,
the wrong something.
That's right, Your Honor. It's not the department. It's not anywhere in the chain of command, for example, which might make this look more like some of the precedents that the other side cites. It's an entirely independent entity. And as far as accountability goes,
To the special division in Morrison, but you also mentioned you had another argument, which is about whether they're actually exercising executive authority.
Whether who is, Your Honor, the
Whether
advisory board?
Inferior officer. Give us all your ways of distinguishing Morrison.
Well, so my point was after Morrison, and after Free Enterprise Fund, the Supreme Court reiterated in Sila Law and reiterated again last year in Trump v. Wilcox that there's narrow exceptions, specifically 2 exceptions recognized by the Supreme Court's precedents to unrestricted removal power. And one of those exceptions is not even arguably presented here. It has to do with a multi-member body of experts. The other one is for inferior officers with, I believe the phrase is limited policymaking and administrative authority. Mr. Abramowitz has significant administrative and policymaking authority. I think it's JA 74 through 77.
An inferior officer?
No, he is, Your Honor, but he is not an inferior officer with limited policymaking authority. And I don't even read the other side to be arguing that he is, because if you look at the position description at JA 74.
That's okay. I just misunderstood you. I thought you were saying he's not an inferior officer.
No, Your Honor, he is an inferior
Okay.
officer. He is. But he exercises significant policymaking and administrative authority, and therefore he doesn't fall within that exception.
But here, it's much more responsive to the president in the sense that there's no for-cause protections at all.
So, Your Honor, I
I
think.
mean, when they talked about the multi-member body of experts, that's a for-cause protection, right?
Yes.
So I think the issue is that I think this sort of goes to the point the plaintiffs made about burden and accountability. And I don't think there can be any reasonable dispute that this statute, even though there's not a quote unquote for cause removal restriction, there are a lot of impediments to accountability here. For example, the advisory board, a quorum has to be present for a vote. That quorum necessarily is going to consist of at least one individual from the party in opposition to the party that's running the executive at any given time, because it requires of the 6 appointed members, no more than 3 can be from the same political party. I believe that's the language. So in other words, in order to constitute an advisory board quorum, the executive has to obtain the presence of the opposing party. Also, if
It doesn't need their vote.
I'm sorry?
It doesn't need their vote.
No, but requires their, not necessarily, but requires their presence. Also,
The Secretary of State and the 3 co-partisans, I mean, all of them are selected by the president, but the action can take place without any, as you said, somebody who might be opposed, at least if you identify opposition by party membership.
I believe that's correct, Your Honor. But the other kind of impediment to standing up an advisory board is that they all have to be Senate confirmed. That, of course, is a process that takes a long time. And
If I could come back to Judge Pillard's point, it seems that there are 2 ways to remove the Voice of America director. One is a supermajority of the advisory board could do it without even any recommendation by the CEO, or the CEO could recommend it with a majority of the board approving. And so it seems to me that what you call the diffuse path, which is the CEO and then approval, actually aggrandizes presidential power, because with that path, which is the diffuse one with the CEO and the board acting, it can be done with all people of the same party as the president, because the CEO is appointed by the president and 3 members of the advisory board, and the Secretary of State is appointed by the president. So the CEO could do it, and then 3 members of the president's party plus the Secretary of State, who's a member of the president's party, can effectuate that removal. Without that, you need a supermajority, which is, I think, defined as 5, and you would need at least 1 person from the opposite party to join in. So to the extent that it's diffuse, it seems it aggrandizes presidential power if you add in the CEO way to do it.
I don't think that's right, Your Honor. I think this statute sets up a means by which Congress sought to restrain the executive's removal. Otherwise,
It
the
does,
CEO would be able to remove.
but when you compare this to other ways in which this has been done, the concern you have is that this dilutes the president's authority to manage the executive branch and call the shots and control what's being done. Having approval by a multi-member department head of a removal, that's been upheld. That's allowed. I know that you have a different argument that this is a different department, but that's okay. And you say, oh, but this is diffuse because there's a CEO that's a head and this other department head. But my point is just that the diffuse option only aggrandizes presidential power because it gives him a method to effectuate the removal with all members of his own party, even though the advisory board is bipartisan. Because for the advisory board to do it by itself, it needs a supermajority. You would have to get somebody from the other party to agree. So the CEO version, you can do it with all members of the president's party.
I think the point you're making, Your Honor, aligns with basically the way the plaintiffs are looking at it, which is they're saying, well, this isn't more of a restriction or this isn't more of a limit on the president's power than these other examples that we've seen, and therefore it's okay. But setting aside the factual points that I already made about the amount of the burden imposed on the executive's authority, the problem is that this court would be going out in new territory where the Supreme Court has recently reminded us we're not inviting making new exceptions to unrestricted removal. This is a new exception to unrestricted removal. And so
Except that it's not, because all the members of the board are removable for any reason. They report to the president. So, and you said, well, he fired them all, so he would have to get Senate advice and consent to replace them. But that would be true if, the SEC is supervising somebody, an inferior officer, and the president decided to get rid of them all. It would be a process to get more people. And the more fickle and arbitrary the president is, it might take longer to get people willing to serve. But that has never been viewed as a constitutional defect in Congress having a multi-member head of department and having that multi-member head of department be the decision maker on removal.
So I just want to make sure I'm responding to your question.
No, which wasn't really asking as a question, but so you were saying, and I think as a practical matter, you're right, that it could take some time for the president to stand up a board because he's fired them all. And so he has to have time on the Senate floor to get new people. And all I was saying was that to the extent that we have, it's standard that you can have a multi-member body like the SEC, and that it can have removal and authority over inferior officers. It also is, in some sense, a practical impediment if the president has fired them all, that the president would have to bring them all back in order to be able to effectively remove an inferior officer.
So
in any agency, in any commission or body.
So to be clear, I don't think this court even needs to get into weighing, to what extent does something like Senate confirmation requirement impede the president's authority. I don't think the court even needs to get to.
That's the only reason I'm talking about that.
I'm pointing to it in response to what I perceive the other side to be arguing, which is that, this isn't really that burdensome. But our top line point is that this is a novel removal structure. The Supreme Court didn't say in Free Enterprise Fund, okay, we think this is okay now that we've gotten rid of one layer of for cause protection. Therefore, we can, go
they
forth.
did okay what was left.
They okayed what was left, but my point is they
was
didn't say
maybe more architecture than we even have here.
But they didn't say, now go ahead and Congress and you can make removal restrictions that are analogously burdensome. They didn't say anything like that. They said,
is your position that anything novel is bad? Anything that's novel has to be overturned? Because that's what I'm hearing. Anything that doesn't fall within what has happened before, we cannot uphold it, even if it does not burden the executive in his authority to control the executive branch?
no, so again, this does burden the executive on its face,
But I do hear you saying anything novel has to be overturned.
I'm not saying that necessarily. There have, of course, been cases in the past where the Supreme Court has looked at a situation for the first time and has decided up or down, do we think this is constitutional? What I'm saying is that this restriction, this diffusing between two different.
So instead of looking at the novelty, we should be looking at whether it is burdensome on the executive's ability to control the executive branch.
I think, Your Honor, so first of all, I think Your Honor should
Is that a
resolve.
yes or no?
I don't think it's either a yes or no. I think you should
I'm
be
sorry, I'm
looking
just
at
trying to pin
whether.
you down because you keep saying this is novel, we have to overturn it. When I asked you point blank if that's true, you said no. And if that's not the case, then what is the operative analysis? It is whether this burdens the executive and his ability to control the executive branch, is it not?
So you should be looking at it whether it's novel. To be clear, I just don't want to be heard to be saying for all cases in the future that might be construed as novel. I don't want to be speaking for any hypothetical case. For this case, you should absolutely be looking at the fact that it's
So
novel.
just because it's novel, we should overturn it.
You should overturn it because it's not within one of the two narrow exceptions the Supreme Court has
So in
recognized.
other words, your
for
answer is
restriction.
yes, anything that's novel is overturned.
I'm saying that I'm not trying to be evasive. I'm saying absolutely it matters that it's novel because this.
And that's dispositive.
I'm saying it can be. I think the court doesn't even need to get there because this case should have been channeled. The court didn't have jurisdiction below.
We're not
But
talking about
it
channeling
can
right
be.
now.
I understand, Your Honor.
I have a question about, the Constitution says that Congress may vest appointments as they think proper for inferior officers, as they think proper in the president alone, in courts of law, and the heads of the department. That as they think proper, the court in Morrison saw as, giving some significant room, maybe maybe it's tendentious of me to say to be creative, but, that it's a judgment for Congress where and how to vest the appointment authority for inferior officers. That seems like, to the extent that what you're worried about is that this is a different combination of acceptable means, locations, personnel to act as head of department, the constitutional language does seem to arguably invite that.
So if I'm understanding your question correctly, I don't think there's any case that is read as they think proper to say that that means Congress can pick a new head of a new department to do it. Now, that I'm not saying the phrase doesn't do any work. Morrison did involve a different structure than this one.
And new in its own time.
Sure, Your Honor, but I think my point is that as they think proper can't mean that Congress can do whatever it wants, because otherwise
I'm not
we would
saying
never.
that. And responding to the colloquy you're having with Judge Pan about whether we should read Saylor law as sort of fixing in amber the constitutionally acceptable methods for the appointment of inferior officers. And I'm just looking at Morrison, which talks about selection of the appointing power is a matter resting in the discretion of Congress, as between the functionaries named. So there's some understanding by the Supreme Court that Congress has some discretion in how to vest the appointment of inferior officers.
So Congress certainly has discretion to appoint in whether to put that power in the president, in a head of department, or in a court of law. Then there's the phrase as they think proper, but it's not clear, and it certainly hasn't been established by controlling authority, that as they think proper means that Congress can put that authority in a separate entity that could be described as a head of department when the head of the department, USAGM, doesn't have that authority, even though VOA director reports.
But wasn't that true in Morrison, that the Attorney General was the sort of supervising head and the special division was the head of department for purposes of appointment or removal?
Well, the special division was a special court, I believe. And so
It was in Article 3, so it wasn't even here. They're both in the executive branch.
So in other words, it was a different situation because here we're dealing with an executive branch head of department, and there we were dealing with a special court. I think the point I'm trying to make is that was different than a situation where there's already a head of department.
Well,
and now Congress is saying
the Attorney General is the head of the Justice Department, and that was important that Morrison was under some supervision by the Attorney General. But the appointing and removing authority was the special division.
But I don't believe that the court, I read Morrison a day or two ago, and I don't believe the court said that Congress can set up a new head of a new department and put removal authority kind of split between that new head of that new department and a new.
So we've been talking for a while about, a good while about two issues. And can I just ask you as an overall matter, there's also a third issue. And
Yes, Your Honor.
So on that third issue, I don't need to have a back and forth, at least I don't on it. I just want to understand where we are in terms of this litigation. The third issue is about the authority of a court to order the reinstatement.
That's right, Your Honor.
That question has been teed up for the Supreme Court.
Yes, Your Honor.
Cases. If the Supreme Court were to conclude that, would you reach a resolution on that issue in line with your position in this case? Would anything that we've talked about so far matter for purposes of this case?
Well, yes, Your Honor, because even if the court had the authority to order this type of relief in the appropriate
No, I'm
case.
saying the Supreme Court resolves it in your favor. What I'm asking is, if the Supreme Court reaches a resolution on the reinstatement authority
Right.
with your position, then do the other two issues that are teed up, do they matter? Because you would get a win on that issue as a consequence of the hypothetical Supreme Court resolution. Then does anything we've talked about so far, would it matter for purposes of this case?
Yeah, I'm sorry, I didn't understand the question. I do now. Thank you, Your Honor. So we still want a ruling on channeling. You're correct that if the administration wanted the Supreme Court on this issue of authority, that could resolve this issue because it would have to be
What I'm asking is, would it resolve the case? In other words, would we need to do anything else? If the Supreme Court issued a decision tomorrow that resolved the third issue in your favor,
then.
Would there be anything left to do in this case?
Then I think this court could reverse just on that basis and say,
Okay.
District Court, you didn't have the authority to enter this relief. However, we're still asking for reversal on the channeling basis and on the Article 2 basis.
I mean, you're asking for reversal. You could ask for reversal on multiple grounds. I'm just wondering, would there be a need or a cause
I
to
don't
do anything other than that? I'm just wondering, I want your view on that.
understood, Your Honor. We would certainly submit something to the court if that happened, but if that happened, I believe the court could just reverse on that basis.
Why wouldn't we have to address channeling?
I'm
Because-
sorry.
Why wouldn't we have to address channeling? Because we wouldn't, under the channeling route, we would not be reinstating him. The court would not be reinstating him. We'd be saying we have no jurisdiction. This has to be this has to go to the MSPB. So why wouldn't we have to resolve channeling?
So I think I think you're asking a separate question. So if the court did
I'm
rule on
asking the same
channeling.
question. The question is, if the Supreme Court were to rule that the court can't reinstate Mr. Abramowitz, would we have to do anything else? And my question to you is, why wouldn't we have to resolve channeling? Because if we go with you on the channeling route, the court's not reinstating Mr. Abramowitz. It's saying the MSPB has to resolve this, et cetera. The court would be saying we don't even have jurisdiction to reinstate Mr. Abramowitz. It goes to the MSPB. So why wouldn't we have to resolve that?
I think you could resolve that. I think
But would we have to?
I don't think you would have, I don't think you,
Even though it's jurisdictional. So that's the upshot of the question is
right.
you would
So
win on a ground and I think you would get full relief because what the district court ordered and you object to is the reinstatement.
right. And so that's my point, because we're asking for the summary judgment decision to be reversed. I think your honors could reverse it on that basis. Now, it would probably be cleaner to also reach the jurisdictional question for the reason you mentioned as well, even assuming there were a decision, because it is a jurisdictional question.
Would we have to? I think that's where I think both of us.
I think if you don't, the district court is going to still think it has jurisdiction over the substantive claim, and it shouldn't. So that would be a problem, and that's why we're.
No, but it wouldn't matter to you because nothing would happen with that substantive claim if there couldn't be a reinstatement anyway. I guess it seems to me it's just a legal question whether in a situation like this, the jurisdictional issue has to be reached, even if the Supreme Court resolves the third ground, which I think would give you whole relief in your favor. Would we not be able to get to that third question because there's a threshold jurisdictional question about channeling, or in this kind of context, would the fact that you would win on a third issue obviate the need to even deal with jurisdiction, or does Steel Company and its progeny say, no, you got to deal with the jurisdictional question no matter what? So
I think probably the short answer, and the thing I should have said 5 minutes ago, is that I would request supplemental briefing in that circumstance.
Yep.
But
understood.
I appreciate the questions, and I understand where you're getting at.
Okay.
And I mean, there is a problem. I mean, we can hear from the other side, but there is a problem with if we were inclined to think the statute 6205E is constitutionally valid, then there has been no removal. So whatever the Supreme Court would hold in Harris, there's no need to reinstate someone who hasn't been removed.
Well, I mean, so if I am understanding correctly, I think we still have the problem that what the district court purported to do, assuming the Supreme Court were to rule in Slaughter that that's not a remedy that's available, the court's order would be invalid under that holding. So he would have to, in theory, you could imagine a remand where if the court had jurisdiction, and I'm not saying it does because our position is that it didn't, but if it did, then it would have to go back to the drawing board, depending on what this court's order said. But I think if the Supreme Court issued a decision tomorrow, we would request supplemental briefing on what to do now.
Make sure my colleagues don't have additional questions at this time, and we'll hear from the other side.
Thank you very much.
Time for rebuttal. Thank you.
Thank you.
Mr. Schultz.
Thank you. May it please the court. So I think, as we know, the issue in this case is whether the director of Voice of America can be fired by the CEO of the U.S. Agency for Global Media when the statute says can only be fired by the International Broadcasting Board, whose members are removable by the president with no for-cause protection. Both the jurisdictional issue, which you've been discussing, and the appointments clause issue are informed by the statute that Congress enacted in 2021, which was designed to protect the director of Voice of America and the other networks from exactly what happened here, namely the firing of the director by the CEO of the U.S. Agency on Global Media. That statute was a reaction to events that occurred in 2020 when a new CEO of USAGM abruptly fired several network directors, prompting a strong reaction from Congress. And this included a highly critical bipartisan letter from 7 senators stating that this action threatened the network's core mission, which is, quote, to act as a bulwark against disinformation and credible journalism, and undercut the credibility and independence of the networks.
But Mr. Schultz, there's a core tension in your position, which is that on the one hand, CC205E is intended to protect the independence of Voice of America, but it doesn't actually render it at all in any meaningful way independent of the president. So, I mean, if the objective is to shield it, then doesn't that cut in favor of the government's position on the constitutional point?
I don't think so, Your Honor. We first look at, I think, what Congress did, and, Congress was concerned that the independence would be impaired if the CEO could, on a whim or for any reason, fire the director of these networks. That was Congress' concern, and they addressed it. I mean, maybe they could have made VOA an independent agency. They didn't do that. They addressed it by empowering this 7-member board appointed by the president, confirmed by the Senate, to have the sole power to appoint and remove the network directors. I'm not arguing that gave VOA complete independence, but it was the step toward independence that Congress chose in reaction to what had happened in 2020.
What if Congress had vested removal authority in a board of 20 that had to be unanimous? Constitutional or not?
I'm not seeing how that would be different, but maybe I'm missing something.
As long as they're at will. Your theory is as long as they're at will.
Yes.
That's still not a constitutional.
Yes. I mean, the president's authority to appoint the board remains. It probably helps us that it's not unanimous.
What if they had to all be of, or a majority had to be of the opposing party as a check to make sure that there's more independence?
I don't know. I have to honestly say I don't know the answer to that question. I mean, that
So
raises
it's the opposing party part that creates the issue, because it sounds to me like you think as long as it's not just as long as it's at will, because if you interpose at will, but with some being an opposing party, say a majority being an opposing party, then that might be a constitutional problem.
I don't know. I mean, the president gets to appoint all these members, right? And so the president can pick whoever he wants as long as it's balanced, which is an arrangement we have throughout government.
Right. So can't pick whoever he wants, but can pick whoever he wants subject to the conditions that are laid out.
Subject to, yes, and subject to Senate confirmation. But he has wide range in making this selection. I think it would be a little odd to say some have to be from the opposing party, particularly since they serve across presidential administrations. I don't even know if you could, how you would do that. But I think that raises an issue that we don't really have here, respectfully.
does it matter how many layers of at will? Suppose it's 20 layers of at will you have to go through. 20 multi-member boards. They're all at will, but it's 20.
Well, it seems like it would matter, yes.
No, I'm not trying to.
I'm not saying
I'm
what's
just trying to
constitutional and what's not.
Yeah, I'm just trying to understand
But-
what the principle that you have for dividing what's constitutional and not. And that's obviously the purpose of teasing out these hypotheticals, is just to know at what point, because I think it's got to be true that the whole point of the existence of this board was to make removal more difficult. At
Yes.
some level, it may not be.
Yes.
And in your view, I'm not saying that necessarily means it's unconstitutional, because your point is, well, sure, it was meant to make it more difficult, but in a way that was important, and it didn't get to a level where it unconstitutionally impinges on the president's removal power. That position is totally coherent, but I guess I'm just wondering, at what point does it essentially impinge on the removal power? What's the principle that tells us? Because
I think that what really helps us here is the case law. And so in Morrison versus Foster, as the court knows, Congress had an arrangement, maybe different purposes, but where the judiciary made the appointment, maybe it was looking for independence, but the special counsel was supervised in the Department of Justice. In the same kind of arrangement was upheld in another Supreme Court case, ex parte Siebold, where the judiciary appointed an election officials, but they were supervised in the Justice Department. And that case also talks about U.S. Marshals, which in some cases were appointed by the court, supervised by the Justice Department, but worked in the court. So these kinds of branch arrangements have been blessed, and our position would be an interdepartment division like this can't be more problematic than an interbranch one, and the court has
I understand that argument conceptually, and it has force. I guess the question is, and understandably, you're not even prepared to say that every interdepartment condition on removal would be okay, because if it's opposing party majority and 20 layers, but it's interdepartment, I think you're suggesting that it could be a different question, understandably.
Yeah, I think it is. I think what we would say, the burden on the president here is minimal, and it's throughout the government. I mean, if the president wants to fire an administrative law judge in the Security and Exchange Commission and the commission doesn't want to do it, his only remedy is going to be to fire enough commissioners and get them reappointed to get his way. And this is true in other agencies as well. And so I think our main point is the burden here is comparable and less than what we see in the government and what the Supreme Court has endorsed in the two cases that I just mentioned.
We've sort of jumped ahead to the constitutional issue without asking you about some of the statutory question.
No, I thought that just wasn't going to be a problem.
So I have a question about, so Abramowitz is both inferior officer and senior executive service. If he were not in senior executive service, would the CSRA still apply?
I don't think I'm not an expert, but I don't think it could apply if he were not.
I mean, not every officer
doesn't.
appointee is a SES, right? That's a career designation, I think.
Yes. And he has that career designation.
But he could be otherwise. Could be just
I think so.
the head of Voice of America, director of Voice of America, without being that.
I think that's true, yeah.
And if he could bring the 6205 claim in district court, does that preclude him from bringing a claim to sort of protect his personal interest in MSPB? Or does it?
I don't know. I mean, we felt he had to make a choice, and the problem with the MSPB is it doesn't work. And maybe I could explain that, talk a little bit about the Thunder Basin factors because I think that's what's critical. So as the court knows, the whole reason you do this analysis is to figure out the congressional intent, Judge Pan's first question. That's what we keep coming back to. What would Congress have intended? Would they have intended that this kind of claim go through federal court or go through the Merit System Protection Board? And the three factors I want to stress, and it's in our briefs and probably everybody knows it, but they're guideposts. You don't have to. Justice Kagan, I think, said in Axon, you don't necessarily have to win on all three, although we think we do, and I'll explain why.
You think you do win, you don't think you do have to.
Right. Yeah, exactly right.
And are they exhaustive? I mean, they're just suggestive, right? Other things matter. As in,
I think so. I think, at least in our case, we can get the other things within the consideration of those factors. But the first one, which is always takes the most time, is meaningful judicial review. And here, the problem with delaying judicial review is really not different from the problem that the Supreme Court was talking about in Axon, because during the time of the delay, the VOA will be operating illegally. They'll be operating without the director that Congress intended be there unless removed by this board, which hasn't happened. And so during that whole period of time, maybe 2 years, 3 years or more, the law is being broken. And you can't, just like in Axon, you can't really.
Isn't that true for every time somebody gets removed unlawfully and therefore they're not in their position?
It may be, but I think the difference here was that Congress's whole purpose was for the VOA to operate with this independence. And if you require going through the MSPB, then every time a network director is fired, you get this long delay and you essentially nullify the statute. Because what does it really mean if the director can be removed for some number of years, maybe as long as an administration?
But if you had a statute that bars, just hypothesize a statute that deals solely with removal and it bars discriminatory removals, and then you had somebody that claimed they were removed in violation of that statute that bars discriminatory removals because they were removed for a discriminatory reason, do you dispute that would have to go to the MSPB?
I think so. I mean, there is one exception for certain kinds of civil rights cases, but a lot of those, certain kinds of discrimination could. And the employee can get back pay. That's the remedy. But I mean, here, you really don't have anything left of the statute, or very little, if you allow this. And so my only point, Chief Judge Srinivasan, is that this goes against the congressional intent. And the whole thing we're looking at here is the congressional intent.
You're not really, you're not really making a First Amendment argument. It has overtones of that, where arguably, I got run away by your friend on the other side when I said arguably, but if one thinks that there is a free expression, freedom of the press kind of interest that Congress was pursuing in enacting the statute, it isn't technically the freedom of the press. It's government speech of a sort that Congress thinks should kind of mirror a free press in a way. Does that change? Does that help you distinguish other delayed relief from what one would think Congress intended here, or not?
I think it may. The whole point of Voice of America and these other networks, and the whole point of what Congress did, was to foster some independence from political appointees and to foster really a network, a news organization that it could operate like news organizations do without that kind of interference. And I think maybe that does help us. I mean, again, I would say it's like Axon. If Abramowitz goes through this MSPB process and prevails, there's still, back pay is not going to help him. There's still no remedy for the long time where the agency was operating without a duly appointed director.
So to give us your most crisp argument for why we shouldn't take this statute to create a substantive standard that MSPB has to apply, like the Constitutional Equal Protection Clause provides a substantive standard that the MSPB in Elgin had to apply. So no reason to exempt Abramowitz from the usual scheme.
So first of all, Elgin involved an employment statute. We have no employment statute here where really the statute is 60.
Employment and removal is a form of employment.
It's a form of, but he was removed under an employment statute that said he had to comply with the selective service. But I think more important.
Wait. But isn't Abramowitz the letter saying, you go through all the factors, you've been basically unwilling to serve the interests as the CEO defines them and going where our need is greatest, which is Greensboro. And so that's an employment, it's put forward as an employment decision. You're the big guy and you're not acting like the big guy. So we don't want you.
Right. But
that's an employment decision.
Yeah, I'm not saying it wasn't. I mean, yeah, he's an employee at some point. But you asked me for my most crisp answer. Let me give it to you.
Okay. Okay.
In Elgin, in addition to the constitutional question about the constitutionality of the selective service, the court says at the end of the opinion, there are, quote, many threshold questions that may accompany the constitutional claim, including, now I'm not quoting, but including preliminary questions unique to the employment context, such as whether this employee was constructively discharged. And essentially, and then it says, and the resolution of those decisions could avoid ever having to even get to the constitutional issue. That's a very different context from what we have here. There is one issue here. It's the constitutional issue. The MSPB has recently said they don't decide the constitutionality of statutes. And so I would say we're in a very different situation than Elgin.
As applied, if this were a case in which there was somebody other than Mr. Abramowitz directing Voice of America, the person was, running amok, embezzling, and the CEO said, you're out, and allegedly embezzling, and
Right.
you're violating, civil service, or you're acting, whatever, conflict of interest, whatever is under civil service, but really bad action, you would have both. So you would have what? You would have both, something that might be susceptible of consideration. It would be like Elgin. There would, maybe they decide, oh, that was all rumor and false. You get your job back, obviate the need to reach
I think
205E issue. So that's a very case-specific reason you gave, because you could see a case in which they were both sort of run-of-the-mill employment
you
claims and
but his you could, but his argument would be, I can only be removed by this board. I can't be removed by the CEO, either because I didn't accept a transfer or for whatever reason. That all has to be done by the board appointed by the president, confirmed by the Senate. Just the way, if there's a problem with an administrative law judge, that judge in the SEC, that judge has to be removed by the SEC, can't be removed by the president or somebody else. I should say a word about the collateral and expertise tests. I think those are actually pretty simple in this case, although maybe you'll prove me wrong with your questions. But surely this is collateral to what the CSRA is designed to address, which is, it's an employment statute and it's collateral to the work of the MSPB. And just as in Axon, again, where the court said that the plaintiff's claims don't address procedural and evidentiary matters ordinarily handled by the Securities and Exchange Commission and the Federal Trade Commission. Here, the plaintiff's claims do not have any relationship to the employment matters ordinarily handled by the Merit System Protection Board. And so we think there's really no difference on the issue of collateral between what's going on here and what went on in Exxon. And the expertise, I think, is the same. The MSPB doesn't pretend to have expertise on these types of constitutional issues. And in fact, it recently said in an opinion, and this has been its longstanding position, that it doesn't decide the constitutionality of federal statutes. And Justice Thomas basically said he understood that was their position in Elgin. So it's sort of long and well accepted. Again, in Axon, the court said, this is a quote, the commission, the SEC, knows a good deal about competition policy, but nothing special about separation of powers. And we think the same is true here. The MSPB knows a good deal about employment policy, but nothing special about Article 2 of the Constitution.
So is it correct as a procedural matter that if this were channeled, the MSPB would just not rule on the constitutional challenge, the constitutionality of the statute, and it would just wait for the federal circuit to review it de novo on appeal?
I mean, my understanding is that first go to an administrative law judge. I don't know what the administrative law judge would
they
do.
rule on the constitutional?
I don't know. I don't know. But I think based on the history, after whatever time it took, once it got to the MSPB and after whatever time it took them, based on the history, they would not rule on the constitutional issue because frankly, they don't have the expertise and it's collateral to the work that they do.
Well, do we know anything about the relative delays in processing something through MSPB versus district court? Like if this seems like an easy question for MSPB, they'd say statute says you got to get the majority of the board. They didn't even go to the board. You win. And then the government would go to the federal circuit and say, actually, that statute's unconstitutional. And that would probably be no slower than something to district court and coming to us, or would it be?
Well, the district court can act very quickly, as it did here. And in another situation, a district court can grant preliminary relief, which the MSP can't do. I mean, that difference has been identified in a number of cases. I mean, in Thunder Basin and in the AFGE case in this court, which was relied on very heavily, there the argument was preliminary relief. The difference between those cases and this case, in those cases, the administrative agency had expertise to decide the issues. But here, I think the preliminary relief that a district court can grant is really critical to protecting the statute. I mean, it wouldn't go to the administrative law judge until, you get in line. I don't know. The administrative law judge might decide the issue. I don't know. But from everything I can tell, the MSPB, they'd have to change their policy to decide this kind of. But either way, they don't have the expertise, and it's clearly collateral to the kind of work that they do.
I'm sure my colleagues don't have additional questions for you. Okay. Thank you, Mr. Schultz.
Thank you.
We'll give the government 3 minutes for a rebuttal.
Thank you, Your Honor. Just a few quick points to reiterate and to respond to the other side. So I just want to go back to Axon really quickly. Axon actually distinguished Elgin on the basis that in Elgin, that was a challenge to a specific substantive decision, such as, quote, firing an employee. And then it distinguished the case that it was before the court in Axon, saying the plaintiff's claims are, quote, instead challenges, again, as in free enterprise fund, to the structure or very existence of an agency. On the collateralism, or I'm sorry, on the adequate judicial review factor, the court then said, adequate judicial review does not usually demand a district court's involvement. Review of agency action in a court of appeals can alone meaningfully address a party's claims. And then the court went on to explain why that wasn't the case in that instance. And that was because of the unique harm, the here and now process harm alleged by the petitioners in that case.
You distinguish that by saying that here the Article 2 point is being raised by the government, but does that matter? Because Abramowitz is saying the structure of very existence of the decision maker is at issue. It's just the flip side of the same, the very same kind of question.
So
Who makes the decision that the plaintiff is subject to, and is that constitutionally structured, that decision maker?
So
Isn't that really just exactly analogous, but flip side?
Your Honor, it's different because Mr. Abramowitz is saying I was removed by the wrong person. The Axon petitioners were saying that the process through which we're going to be required to adjudicate our substantive grievances is itself unconstitutional.
Well,
So-
and here he's saying the process of the firing was itself contrary to Congress's dictate, and the government is saying, oh no, constitutionally that was wrong. So there's a question about removal, about accountability in both cases. But here, Abramowitz is saying Congress has the authority to create the structure that protected me. The executive is wrong to blow it off. And there, the plaintiffs in Axon, and in those two cases, was saying that the entity that has ability to make decision over me is Congress was wrong to create it this way. The executive is right, but it's the same structure, is it not?
No, Your Honor, I think what would be closer to that would be if Mr. Abramowitz was challenging the constitutionality of the MSPB process, which I realize we already discussed, but that would look much more like what happened in Axon.
So your argument is a one-way ratchet. If you're talking about the limitations on executive authority or accountability, then it's collateral and out of the expertise. If you're talking about the permissible exercise of Congress's power over these decisions, then it's not.
No, I don't think that's what I'm saying, Your Honor. I'm saying what was really driving the court in Axon was the nature of the harm and the fact that it couldn't be remediated later. And so I think, kind of to segue to another point,
What about Mr. Schultz's point that what cannot be remediated later is the loss of independence over this period of time?
So I think
Equivalent to these immunity cases and other cases.
Right, Your Honor. So I think that bleeds into the Chief Judge's question to my friend on the other side, which is, couldn't anyone who's removed, I'm paraphrasing, Your Honor, but couldn't anyone who's removed argue that a statute's purpose is being violated for the duration of their removal? And of course, they could make that argument, but that still says nothing about where the challenge should be heard in the first instance.
No, this question is about remediation. You can argue that, but normally reinstatement and back pay, et cetera, is considered adequate to compensate somebody who's before the MSPB. But I thought you were saying that in Axon, there's a structural issue that, once you've gone through the process, you've already lost that interest. And Mr. Schultz was saying what's equivalent here is the loss of independence of the Voice of America. You can't get it back. So it's you can't remediate it. And that's why this is different from those typical MSPB cases where you get back pay, you get reinstatement. That's enough for you. Not here.
So respectfully, Your Honor, I disagree with that characterization because, again, he could, as you noted, he could get the reinstatement, he could seek the back pay, but he's not vindicating some broader interest, some purpose of Congress. He's vindicating his interest in his job. That's what would be before the MSPB. That's what was before the district court.
Yeah, but you're sort of evading the question because that is one thing that's before the MSPB. But Mr. Schultz's point is that there is this other thing that cannot be remediated by the MSPB, which is intended by the statute that he's relying on.
I think maybe what I am trying to articulate is that Mr. Abramowitz is not the party he's not a party bringing a claim that can remediate that in any forum. His claim is I shouldn't have been removed. I want my job back. And so
Maybe this just goes back to congressional intent then?
well, Your Honor, I think
Who stands for the proposition that Voice of America would lose its independence, allegedly, arguably? That is what Congress was intended to address with this statute. Mr. Abramowitz is saying you're firing me in violation of this statute. Mr. Schultz is saying there's an issue here that cannot be remediated by the MSPB with its normal remedies. And you're saying nobody can vindicate that intent of Congress?
No, Your Honor, I'm saying that what we might or might not feel was the intent of Congress can't vary the fact that Congress made a substantive restriction, but it didn't purport to vary the background presumption that these types of claims go to the MSPB. And that's what I'm saying. I'm saying you can't use what you think is the intent of Congress to say this should alter the relief I
the
get.
whole ballgame in this whole analysis. What did Congress intend?
I think that's a weakness of the other side's argument, Your Honor. They're making a very strong pitch in their view for the intent of Congress, but that can't vary what the statute does and does not require. So that's
I'm sorry.
my
We're
response.
in determining what the statute does or does not require. We are analyzing what Congress would have intended, whether Congress would have intended that this claim be channeled. It's all one and the same analysis. So I'm not understanding your answer.
My answer is that in the statute, in Title 22, which is where 6205 is, the Congress didn't take the claim out of channeling. And this is the quintessential type
you're
of
saying. This is the question we're trying to answer, whether they did or didn't. And it's not explicit, but it's never explicit.
I guess I don't know if I have another way to answer your question, Your Honor. I think that to the extent the other side is using the perceived intent of Congress to tell this court where its claim should be heard in the first instance, or where Mr. Abramowitz' claim should be heard in the first instance, it doesn't say anything about that. It says this is a substantive interest.
Are you disputing that that's the whole Thunder Basin analysis, that we're trying to ascertain the intent of Congress as to whether this claim should be channeled?
No,
That's what
Thunder
we're doing
Basin. I don't think that I didn't understand myself to be disputing that Thunder Basin sets out ways to get at the intent of Congress. And I've been talking about Elgin, which follows Thunder Basin, and Axon, which follows the Thunder Basin inquiries. I'm not disputing we're under Thunder Basin, but I think my point is that the type of analysis in which the plaintiffs are asking this court to engage is not something that's been blessed by Axon or Elgin or Thunder Basin. So I think if we're going to look at the intent of Congress, we should do it in the way that the Supreme Court has done it, which is look very closely at the type of harm being asserted and the type of relief being sought. The type of relief being sought and the type of harm being asserted here are quintessentially the types of things that the MSPB deals with all the time. So with that, I would ask the court to reverse. Thank you very much.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 25-5290, American Federation of Government Employees et al. Appellants versus Donald J. Trump, President of the United States of America et al. Ms. Golden for the appellants, Ms. Welch, the appellees.
Morning, Ms. Golden. Please proceed when you're ready.
Good morning, and may it please the court. Caitlin Golden on behalf of the appellants. I'd like to reserve 3 minutes for rebuttal. Defendants have all but eliminated the United States Agency for International Development, an agency created by Congress to provide humanitarian assistance around the world. That closure violated the APA, was unconstitutional, harmed plaintiffs, and will cost millions of lives around the world. All of the issues before the court today go to whether plaintiffs' claims challenging that closure can be heard in federal district court. They can. First, Oxfam has standing. When the agency closed, it dramatically altered the humanitarian landscape. Tens of billions of dollars in foreign aid vanished, and USAID staff's deep expertise in administering humanitarian assistance disappeared. Without USAID, it will be more difficult for Oxfam to fulfill its mission of ending poverty and offering life-saving support in times of crisis. Oxfam has been forced to expend resources to address the loss of funding to partner organizations, and in some cases may be forced to abandon projects entirely. Oxfam has lost the invaluable resource of USAID partnership, expertise, and collaboration, and its efforts to provide life-saving support have been impeded. Second, the two union.
Can I just ask you about Oxfam standing? If you were going to switch to somebody else's standing.
I was so happy
Okay.
to talk about Oxfam.
Okay, sure. On Oxfam itself, and I can understand why you started there because the channeling inquiry might be more clear from your perspective with respect to Oxfam than with respect to the unions. So with Oxfam, it seems like there's two theories that you have for why Oxfam has standing. One of them has to do with the notion that USAID is a magnificently large presence in this domain. And if you remove them from the equation, it creates all kinds of effects, including that Oxfam is going to end up maybe having to stop doing some things that it is doing now because there's going to be some voids elsewhere that it needs to fill. That's one way of, I think, characterizing the first one. And the second one is that the absence of USAID makes Oxfam's work more difficult because USAID isn't there as a partner or as a source of guidance and things like that. So if we just focus on the first one for a second, is that a fair, at least, characterization of the two?
Yeah, I think our first injury is that the loss has caused Oxfam, it has made Oxfam's work more difficult from a funding and gaps perspective. And then the second injury is the loss of the expertise and know-how. So I think your characterization is fair.
Okay, so on the first one, is the idea that because USAID, under your understanding of the situation, no longer exists or is threatened not to exist, then there are initiatives going on in areas that Oxfam cares about, and those are not going to just happen. They're either not going to happen at all or they're not going to happen as well. And so Oxfam has to reconfigure its resource allocations so that it stops doing something that it's doing now and it starts doing something that somebody else used to do but can't do any longer because USAID is not on the scene.
I think the injury to Oxfam is more direct than what you are stating. So Oxfam performs its work with partners, and that might mean that a partner is handling one piece of a crisis and Oxfam's handling another, but it also means that there are situations where Oxfam and a partner are working on projects together.
Okay.
And so we give one example in our declarations at JA 138, where Oxfam was working with a partner in the South Sudan to build latrines and provide clean drinking water. The Oxfam was bringing one set of money to the project. A partner was bringing another. That partner lost their USAID funding. And so Oxfam was forced to put the project on hold and was in a situation where it would either need to incur a budget deficit to wind down the project or move money away from its other work to keep it going.
So thanks for that clarification. So then if we're focusing not on a substitution effect, but we're focusing on work that Oxfam is already doing in partnership with somebody else, and that work either becomes impossible or at least a lot more difficult because the partner's impaired by the elimination of USAID, the non-existence of USAID. And I guess my question is this: if you have a circumstance in which Oxfam is working with one partner on a project that matters a lot to Oxfam. And then that partner is funded by USAID. And USAID, it's not the elimination of the entire department, but USAID just terminates its contract with that partner. Does Oxfam have standing to litigate the lawfulness of the termination of the agreement with that partner because it affects the ability of Oxfam to carry out its mission vis-a-vis that project in which it's engaged in partnership with the organization that has now been defunded?
I think in that situation, you would look to the standard for organizational standing and whether or not that closure undermined Oxfam's ability to engage in its core business activities. And in the situation we are in, it wasn't just a single project in South Sudan. It was projects across the world. Oxfam operates in 80 countries. And so I think here
Is it a question of scale?
I think in part, whether or not something undermines an organization's core business activities is really going to be a fact-specific inquiry that looks at the impact of the government action on an organization's abilities to carry it out. And so that there may be situations where one contract might be enough, but this is a different situation. An entire pillar of the humanitarian space was wiped out, jeopardizing Oxfam's projects across the world and forcing it to engage in these decisions worldwide, not just with one contract. And so
is it a question of what claim the plaintiff is bringing? Because in listening to the chief judge's hypothetical, it seems that there is a line between sort of third party standing. So if you were challenging the cancellation of a grant to a partner that Oxfam was working with, that would be like a third party standing thing. But if you're just challenging the dissolution of the whole agency, that's not third party, that's just indirect effects. I guess I'm interested in the difference between indirect effects versus third party standing.
Sure. So this is not a situation where we are asserting standing based on the termination of the grants. You're absolutely right. The fact is
because Judge Nichols thought it was third party standing. So it's interesting to understand why that's different.
Yeah. So here we're not asserting injuries. The injury Oxfam is asserting is not the injury that its partners experienced when they lost its funding. It's the injury Oxfam has experienced because the partners lost
But
their.
in a third party standing. Oh, go ahead.
I think you could say exactly that thing with a one party situation two party situation where it's just Oxfam and a partner. You could say, sure, the partner has its injuries of its own. There's no doubt about it. But Oxfam has its own injuries because it can't carry out its own mission as well because the partner is no longer able to be on the scene in the same way because they lost their funding.
So I think I agree with, I'm fairly sure I agree with that. This is a situation where Oxfam is not able to do its work because of the partner's loss of money. And you're correct, Judge Pan, that we are not challenging the termination of those grants specifically. We are bringing APA and constitutional claims challenging the wholesale closure of the agency. And so I do think that puts us in a different situation than a third party situation where we are terminating or challenging the termination of those grants. And again, Oxfam was facing this situation across the world. The closure of the agency jeopardized their projects, forcing them to incur additional responsibility. And it's made their life-saving work less effective in the humanitarian space. The efficacy of any work depends on activities of its partners, whether it's in partnership with Oxfam or working side by side.
Can I ask about this, the second branch of the Oxfam? So in that, which is that the theory is that Oxfam is directly affected by the absence of USAID itself as a partner of sorts, or at least a source of guidance or something like that. Is that USAID itself is providing the guidance, the service that Oxfam needs, or is it that USAID is working with somebody else who's providing that guidance or service, and the absence of USAID makes that other party less able to assist?
It's that USAID was providing it directly. So USAID provides evidence, research, technical know-how that Oxfam and other humanitarian organizations rely on in doing its work. So that's a service that was provided directly by the agency. There's no intervening third party.
And you think that's different from information? It's not an informational injury. It's not that USAID is giving a report or something like that. It's an actual direct service that USAID, is that the difference you would draw from the informational injury sort of idea?
I think so. So it is that USAID staff brought expertise and technical know-how to the field. Oxfam relied on it. And when that information disappeared, their reliance interest was injured. And so I think this is like the Doctors for America case that we cite in our papers, where HHS posted information online that doctors relied on in serving their patients. And when that information was removed, it made their work more difficult. And that was enough for Article 3 standing. That's the same here.
Didn't you allege that USAID would send flights, like planes, into areas that you couldn't access without them? Like, isn't that much more direct?
My understanding is that is a service USAID previously provided, yes. And so
That just seems much more concrete than all this informational stuff. So I guess I'm wondering why you're not relying just on that.
I think our declaration is not specific about whether or not Oxfam rode on those flights. And so we are.
Did Oxfam not ride on those flights?
I don't have a representation about that. And so I think this is a situation where they provided this research and technical know-how. This is also like the Action Alliance of Senior Citizens of Greater Philly versus Heckler case, which is at 789 F2D 931, where HHS regulations cut off the flow of information that made it more difficult for an organization to counsel their elderly clients and refer them for services. Same here. This is a situation where USAID provided information, technical know-how, and expertise, and cutting off that information is making it more difficult for Oxfam to do its life-saving work.
So if you call it information, then does it fall in the line of informational injury cases? I thought you were saying that it doesn't.
I don't think it does. I think, informational injury cases involve a statutory right to information and then non-provision of that information. This is more of a situation where there is a reliance injury to Oxfam based on the removal of the research and evidence that USAID provided.
Mm-hmm.
If there's nothing else on Oxfam standing, I'd be happy to turn to the union plaintiffs standing here. AFSA and AFGE, the two union plaintiffs, also have standing. Here, the union plaintiffs experienced an injury in fact, the loss of the members' jobs that can be traced to the challenge conduct, the closure of USAID, and that can be redressed by a favorable decision vacating the closure. That's all that's required for Article 3 standing. Defendant's core argument is that those employment injuries limit the types of claims that plaintiffs can bring. But that's not what is looked at here. When a plaintiff is injured by a policy, they have standing to challenge it. And that's true even when a plaintiff is not injured by every consequence of a policy. So I think it's clear here that the union plaintiffs have standing to challenge the closure.
And how do you deal with cases like Gill? Because it just, one way to understand that kind of decision is that, yes, there was a plan, a redistricting plan that then had an effect on multiple districts because it's a jigsaw puzzle. But then the way the court described the injury in that case was it was a district by district problem. And so a particular voter had an injury vis-a-vis one district, not the entire redistricting plan.
I don't think there's anything to suggest that there were individual decisions made here. So in this case, in this situation, all of the employees at USAID learned that they were going to be terminated in a single email sent by Jeremy Lewin that said, that confirmed that they planned to retire USAID as an independent operation, and said, as part of that process, substantially all non-statutory positions will be eliminated. That's a JA 162. And so there's not a situation where there were individual decisions made. There was a decision made to close the agency, and then terminating all employees was simply implementing the decision to close the agency. So I think this is slightly different, where there was just one decision made. It's not like they went through and decided to terminate each employee individually on a case-by-case
But with the redistricting plan, is there just one map? There's just the creation of one map, and it consists of several districts, but I don't think you can't create one district without thinking about what the other districts look like, because if you made one district look one way, then it necessarily affects what the other districts look like. So it's just one map that's created. But then the analysis in Gill, one interpretation is that it presumed that the injury was as to a particular district, not as to the entire map.
Sure. So I'm not familiar with the exact facts of that case, but I think the distinction here is the fact that there was one decision, and I think it's appropriate here to look at the higher level action rather than any sort of employment specific action as part of the case, because while the pieces of the map may have affected the other pieces of the map, you know, there's not a way to delineate the termination of employees from the closure of the agency. Finally, I'd just like to turn briefly to channeling. Plaintiffs' claims are not employment disputes that are appropriate for the MSPB or Foreign Service Grievance Board. The claims here are APA and constitutional claims. They do not challenge personnel actions. They challenge the unlawful decision to close the agency. There's nothing to suggest that Congress intended for these types of claims to be addressed by those employment bodies. There is no substantive expertise of those employment bodies that is necessary to decide the questions at issue here. And those claims are wholly collateral to the types of claims typically heard by those administrative bodies. And of course, for Oxfam, which does not represent federal employees, those claims cannot be brought before those boards. Lastly, I'd just briefly like to address the issue the court raised regarding the reductions in force. You know, as
It only affects one of the, that speaks to one of the unions, right?
That speaks, so there are two different statutes here.
Yeah.
The MSPB applies to the AFGE employees. The Foreign Service Act, which does not include that, applies to the employees of AFSA. That's correct, the Foreign Service employees. So as I noted, the here there is no reason to assume that Congress intended for APA and constitutional claims like those brought by the plaintiffs were meant to be channeled. But even if you accept the defendant's view of the world that we are challenging reductions in force, that further supports plaintiffs' argument that nothing should be channeled here. The exclusion of RIFs from 7512 tells us Congress did not mean to preclude RIFs from judicial review. Again, we look at whether or not it's fairly, Congress's intent to exclude review is fairly discernible. And here the Congress's intent is very, very explicit. They've explicitly carved out RIFs. And so here we believe that further supports plaintiffs' argument that reductions in force shouldn't be channeled to the MSPB. As for the Foreign Service employees that you identified, you know, the Foreign Service Act is meant to be interpreted as a companion statute to the MSPB. And so it would likely be appropriate to interpret it in the same way.
And does it matter for these purposes that there's the other statute that allows by regulation for RIF claims to be, for a regulation to say that RIF claims can go to the MSPB?
I don't think the fact that there is currently a regulation on the books addressing that is relevant for the inquiry here. The Thunder Basin test looks at what Congress intended, and there is, and so I think the regulation puts is outside of congressional intent. There's nothing in the statute directing the OPM to make a regulation, you know, channeling claims. And so I think that's the silence from Congress is what we're looking at here, not the existence of the regulation.
I thought you were asking a different question about the Foreign Service Act.
Oh, I'm
specifically authorizing the Secretary of State to prescribe regulations. But it also directly addresses reductions in force. So never mind.
okay.
So your theory about, apart from this question under the, for AFGE and the fact that the CSRA excludes RIFs, your theory is that the claim goes to dismantling the agency, not to your clients' employment or not, even though your client's injury in fact consists of employment-related actions. Do you have any other case in which the injury giving rise to the claim is an employment type injury, but the federal employee is not channeled whether through CSRA or through FSL MRS?
I don't have a specific case, but I think that the channeling inquiry looks at the type of claim a plaintiff is bringing, not the injury they have experienced. And so here, the type of claims we are bringing are APA and constitutional claims that do not touch on any portion of the employment injury. And so I think because the Thunder Basin test looks at the type of claim, I think that's the applicable thing to consider
So
here.
there's Thunder Basin, but then Elgin is the one that seems broader and in a way harder for you, because Elgin talks about CSRA making MSPB jurisdiction over an appeal dependent only on the nature of the employee and the employment action at issue. So the nature of the employees are federal government employees who are covered in the category, the types of employees who are covered under CSRA, and the employment action at issue being discharge or RIF would be channeled.
I understand the employment action at issue language in Elgin to be speaking about the employment action at issue in the litigation. So there, the employee in Elgin the employees were terminated from their jobs, and there wasn't any dispute that what they were challenging was their termination.
So you're sort of assimilating Thunder Basin's reference to claim to, like, the employment action at issue is, nobody's disputing that the claim is an employment claim.
That's correct.
Thunder Basin. And whereas if you step back and you say, well, there are constitutional claims, there are APA claims, the action here wasn't, the government didn't wake up and say, let's do some employment actions at USAID. They said, let's take that thing down and move those functions to the State Department. So that's at the level where you think there's actually not a conflict or tension between Elgin and the Thunder Basin analysis writ large.
That's correct.
Does it matter whether we reach AFGE or AFSA standing, and does it matter whether it's organizational or associational for purposes of your case? What are the implications of if we just do Oxfam, or if we do the unions and hold associational or organizational?
I think this case can proceed regardless of whether it's just Oxfam or whether it's Oxfam and the unions. I also don't think it matters whether it's associational or organizational standing. I think if this court finds one plaintiff has standing to proceed, then it's appropriate to remand for further proceedings. Of course, we think all plaintiffs do have standing and that the claims should not be channeled, but the court could just find that one has standing and remand.
I actually do have a question. Your union plaintiffs, clients, can they be channeled to the MSPB? I feel like the MSPB deals with individual employment actions. And I'm just wondering how channeling would work if it happened in this case with your clients and their claims. What would be before the MSPB, and how would that work when it's not individual employment claims being challenged?
Sure. So the individual employment claims of the union plaintiffs members would be before the MSPB.
But that's just not what this case is about, is it?
Well,
I'm just saying, if this case were channeled to the MSPB, what would be litigated there and how?
So if
the plaintiffs are unions.
Sure. So the union plaintiffs can bring unfair labor practices challenges before the labor relations boards. So that is one path. And then there is an alternative path where the individual employees represented by their unions can bring the claims in the MSPB.
So in other words, though, in this case, those are not the claims.
So the individual employees' claims would be to their particular termination. That's correct.
Would the organizational harms to, for example, to either of the unions have a remedy? Could they channel and get a remedy? The organizational as opposed to the associational injuries?
Meaning, could they bring an unfair labor practice, bring some sort of proceeding challenging the practices here?
Would that remedy their organizational harms, an unfair labor practice claim? Or is that just their associational harms because it's affecting their employees?
I think the only way for their organizational harms to be remedied would be for employees to be rehired with the agency, because their organizational harms involve the loss of their membership base. And so
There's no other organizational harm claimed. It's the membership base.
it's the loss of the membership base, and then it's the resources they expended during the course of the shutdown, responding to members and, dealing with their inquiries and issues related to the shutdown are the two organizational injuries we have.
So are they seeking some kind of compensatory damages for that?
Not in this
If they
case.
were able to go in district court?
Oh, we're not seeking any compensatory damages for those losses.
It sounds like the upshot of your answers to this line of questioning is that you would have to bring new and different claims before the MSPB than what you're trying to bring here.
That's correct.
Like these can't be addressed by the MSPB.
It seems very unlikely that the MSPB would address claims like those brought in this case, the APA and constitutional claims challenging the
By
OCA.
unions. Yeah.
Right.
But the unions, the point that it's the unions bringing the claims, where would the union claims get channeled to?
So my understanding is that the unions could bring some sort of unfair labor practice or other.
But that's a different claim.
I'm not disagreeing with you, Your Honor.
Isn't your answer they get channeled nowhere? These claims get channeled nowhere?
I'm just not sure. The law here is complicated, and so I'm not.
So you think there's a possibility that the unions could bring their claims, APA constitutional claims, as unions to the MSPB?
No, I do not think that.
I think that's the question.
Okay.
Actually, that's not exactly the question I'm asking. I'm asking where would the unions, where's the supposition that the union claims would go for channeling? You don't have to agree that they should go there.
Sure.
I'm just wondering where is it contemplated that the union claims would go for channel?
My understanding is that the government is suggesting that they could bring claims under the FSL MRS to channel their claims, is my understanding. Obviously, we don't agree with that, and we think that they are appropriately heard here. But that is my understanding of what the government
And
is.
those go to the FLRA, just to
Yes.
be
Right. That's where I'm
acronymically wild. Yeah.
Yes, let's get all our acronyms out now.
Yeah, but that's the authority to which they would go.
That's my understanding is what the
Of
government is
course,
stating.
you think they shouldn't get channeled, but I'm just.
That's correct.
Okay.
So Congress has repeatedly issued these riders prohibiting the use of any appropriated funds to implement a reorganization or redesign of USAID without prior consultation by the agency with the appropriate congressional committees and without a detailed justification for any proposed action. That's the 2024 legislation. And I just wonder how do you interpret consultation as used in that legislation and detailed justification? And specifically, is it your position that the Secretary Rubio's missive to Congress that we have in the record does not suffice for those purposes?
Sure. So, I think that gets at a merits issue that's not before the court now, but I think our understanding of the consultation requirement is that the missive from Secretary Rubio does not comply with that. It, just merely announces some sort of intent. It doesn't engage in any sort of discussion. And so I think it does not satisfy the standard that's been laid out in the appropriations bills.
You sure colleagues don't have any additional questions for you at this time? Thank you, counsel. Give you a little time for rebuttal.
Oh, I had one other question, which I'd rather ask now than wait for rebuttal and eat up your time. Are there any, I know there are several different cases going on, and have any of the USAID, either foreign service officers or domestic civil service employees, pursued administrative remedies individually to challenge their termination? And do we know anything about the status of that?
So that's not in the record. My understanding is that they have, and that there are various proceedings before the MSPB addressing those issues. My understanding is that there hasn't been any significant headway or substantive progress, though, in those proceedings.
Meaning not even any initial decisions or anything?
No, that's my understanding. Though I can't say I know about every single decision.
Thanks.
Thank you. Ms. Welch.
Good morning, Your Honor. May it please the court, Sarah Welch for the appellees. The plaintiff unions attempt to separate the sweet from the bitter. They seek to rely on their members' injuries from adverse personnel actions, but avoid the exclusive regime Congress established for addressing federal personnel actions. As my colleague just pointed out, they identify no lawsuit that has successfully end-run the CSRA in this way. Instead, this court has consistently rejected attempts to evade the administrative scheme by joining less directly harmed plaintiffs or reframing claims as systemic or constitutional. The unions say their claims fall outside the exclusive regimes governing federal employment actions because they're challenging a decision to shut down USAID and raising constitutional claims. That maneuver doesn't work either. In their complaint, for one thing, they said they were challenging a series of actions, not a unitary action. And the programmatic relief that they're seeking would go far beyond redressing their injuries, which remain employment-based. That would violate the rule that they have to demonstrate standing for each form of relief sought. The only remaining...
That seems to collapse something that I haven't really seen our case law collapse in the past, which is you need to have an injury in fact that's caused by the action you're challenging, by the violation of the law that you're challenging. And here, if they're challenging as a violation of law, the shutdown of the agency, they have various different harms. They don't take you to be saying, no, those harms weren't caused by that violation, by the shutdown, nor that they wouldn't be redressed, but you're imposing a tailoring requirement on a claim. You're basically saying, yeah, you say your claim is an APA claim or, violation, acting contrary to law, but it isn't. It's really an employment claim, and it's reframed. I mean, where does that come from? I don't see that in CASA. I don't see that in Gill versus Whitford. We have, this extraordinary standing doctrine for generations about aesthetic harm. You go and, some part of a wilderness you're in, and it's going to be affected by an unlawful environmental treatment or development or something. And there's not a question, well, could you have brought, a nuisance claim that only affects a corner of that development? And if so, then that's your claim. So you're really making a pretty conceptually ambitious argument. And I'm not sure, I'd like to hear more about where it's coming from and what you think binds us to analyze it in that way.
Sure. So I have a few answers, a few ways to think about that. I think conceptually what we're looking at in this case is how does channeling interact with standing in agency action cases? So one piece of authority about the aesthetic injury standing that I would point the court to in particular, I believe it's the Center for Biological Diversity case that involved challenges to 4,000 different wells that the plaintiffs attempted to group together into a single challenge. And the court said, those are separate actions. You need to demonstrate standing for each of those, even in an aesthetic injury type of case.
Right. Go ahead. I don't want to cut you off.
Sure. And the second standing case I would point the court to is Friends of Animals versus Bernhardt. This is 961 F3rd 1197. And that case involves another attempt to do what the plaintiffs are doing here, which is group together multiple discrete agency actions into a single action that they can then challenge and seek relief from. And in that case, the court said that the memo that was being challenged involved a host of similar but discrete agency actions. And they needed the elimination of many of those discrete actions caused no injury to the plaintiffs, and therefore they couldn't challenge those. So discrete portions of the memo would be set aside if they were successful, but that was all they had standing to challenge. So that, if I could, the other piece of this is how that interacts with channeling. So I acknowledge that they have framed their claims at a higher level of generality, which is a similar move. So these two cases I've cited tell us that that doesn't get them out of the woods from a standing perspective. And the channeling piece is that their claims that that fall within the scope of the CSRA because they are, as the court put it in Fausto, subject to the comprehensive system for reviewing personnel action taken against federal employees, which is undoubtedly, the associational harms at minimum that they're asserting. And I think my colleague on the other side agreed that that's the basis for their organizational harms as well. Once you take those out of the standing analysis because they are channeled to another forum, what's left is that they don't have a protectable legal interest, an injury in fact, with respect to whether USAID retains leases for its headquarters or any of the other distinct portions of the agency action or distinct agency actions that they're challenging.
So going back to CBD, which is where you started, that case dealt with challenging an agency action. An action was the licensing of oil wells. And licensing is something that the agency does in that well by well way. And there may be aspects of the long process of getting authorization to drill that are actually done in a more wholesale way. But the thing that those plaintiffs were challenging was the licensing of individual wells. And they created a construct by saying, this is I can't remember the term, but they said, this is the drill area. And the thing is, that wasn't the government's action. The government's action was licensing of an individual well. So that is more like Southwest Utah, where the plaintiffs are saying, there's a connection here, and I'm going to put them together. But we have the opposite here, where the government and the major decision makers are saying, USAID has got to change. We're gonna put a moratorium on all its work. We're gonna take it down. We're gonna recreate those functions in the State Department. So the question I have is, if that's, what they're doing is they're challenging agency action. I mean, it's simplest to think about it in terms of the APA. Is this a final agency action? And that's really defined by the government and the unit in which it acts, not by the court in assessing the injury that gives a plaintiff the standing to challenge it. And I just haven't seen that kind of, redefining of a claim through the injury in fact of a plaintiff. And I don't think that that the cases that you cite actually stand for that.
So I do think that's exactly what Friends of Animals versus Bernhardt says. There was a single agency memo in that case, and the plaintiffs purported to be challenging that single agency memo. And the court said the proper way to look at it was with respect to the particular pieces of that memo that were actually injuring the plaintiffs. And then I think I think that's my primary response.
Is that a relief question in that case? Or is that a standing?
It was a standing question in that case. The court cited Lewis v. Casey in the same sentence that it was saying standing is not dispensed in gross, and the elimination of many of the discrete actions that were bundled together in a single agency memo caused no injury to the appellants, and so they couldn't seek relief from them.
But they're distinct agency actions bundled together in a memo. The memo isn't then the action. And it seems like that's more the analysis.
The plaintiffs were arguing that it was. I'm sorry, I didn't mean to.
Right. And so were they in CBD. So the question is, well, what is the action? And if let's say we're satisfied here, let's say that, Secretary of State issues a memo and says, we are going to terminate USAID and take all necessary actions to do that. And then we're going to think about what foreign aid functions we want to run out of the State Department. And plaintiffs who are harmed by that, including potential recipients of aid, employees, other partner aid organizations are harmed by that agency action. If there's no question that the agency action was as I described, I'm not sure that Friends of Animals or CBD supports your point.
So I think I read those cases differently, but setting that aside, taking the single memo, sort of hypothetical or how it works in this case.
Not a single memo, but a single decision, an action.
So the most concrete thing
is getting rid of USAID. That's what we're planning to do. That's our objective. That's our action. We've decided it, and we are confident. We're not going to talk about it anymore. We're going to get working.
So we of course dispute that decision was made. We don't think that decision was made.
Hypothetical, just for purposes of the discussion.
And if I could just underline that a little bit, the plaintiffs are pointing today to the final mission memo.
But let's not go there. Let's deal with assuming that there's an action that the government has said. Our objective is to get rid of the agency.
So I think in that case,
we think we have authority to do it. We think either the limitations in the riders are either unconstitutional or don't mean what we said, or we've met them.
So two responses. One is that we still think that the plaintiffs would have to show standing to obtain relief from any of the portions of that action, not separate actions, but portions of that action that they are challenging, that they're seeking relief from. The other piece of my answer, and I think this stands independently, is that all of the attempts to receive relief from personnel actions, even if they flow from a single hypothetical agency action, which we of course don't think happened here, those are channeled, even if they would otherwise be able to be brought in a single APA action. Those are still channeled through the CSRA scheme. And I think that's an independent basis for.
But those are, it's sort of like if I brought a citizen suit under the Clean Air Act, and it seems odd because it seems like if there are nested kinds of claims, there's a big claim, Clean Air Act, federal statute, and then maybe there are also common law claims for, nuisance or something. This isn't legally accurate, but imagine there's sort of these nested other kinds of things. And I want to bring a citizen suit. You're basically saying, well, no, if there's a smaller action that might be supported by the injury in fact you're claiming for your bigger one, you have to go to the smaller one. And even if your interest is different, the relief is different, it's a new way of thinking about standing that I have not actually seen spelled out in cases. And it seems problematic. Does it not seem problematic to you that the plaintiff, who's master of her claim and brings a case, win or lose, is told, no, you have to pursue a different claim?
Sure. So I do think as a matter of how remedies work, that the plaintiff needs to show standing for each form of relief sought. And so if they're seeking something broader than what would actually redress their injuries, they get the more minimal relief that would actually redress their injuries.
That's remedy, whereas you are actually redoing and reattributing to the plaintiffs a claim.
I'm not sure we are.
You're bringing a claim, a civil service claim or an unfair labor practice claim, and they're saying, no, we're not. We're bringing a claim about, a separation of powers claim or a statutory claim. Some of it is appropriations law about the existence or not of an agency, because the decision that was taken was on that level, and that's the law that we're looking at.
So I don't think that piece of our argument is unprecedented at all. I think that's very familiar in channeling cases. It's very normal for a less directly harmed plaintiff or an organizational plaintiff to bring a claim that's framed at a higher level of generality in an effort to get straight to district court instead of going through the administrative process. That's very common in the Tucker Act context.
Except it's not looked at there. It doesn't say you don't have standing to bring, for example, in Elgin, you don't have standing to bring the equal protection challenge to the Selective Service Act. No, sure, you have standing. You're channeled. And in fact, when you come out the other end, you go to the federal circuit and you can argue about that.
Sure.
Right?
So
it's not cutting off standing. So I think you're right that you have a powerful channeling argument because Elgin is basically saying, look at the nature of the employee and the action taken, and we're going to treat that as channeled. But it leaves the other claims that aren't as in the heartland for review by the federal circuit. So it's a different move that you're referring to there.
And I think it's pretty unique to this case, and that's probably why it hasn't come up before, that we have plaintiffs who derive standing to press their broader claim that they say is bundled together in a single agency action. They possess standing to challenge that only to the extent that they have employment-related harms. So once you do the channeling analysis and subtract out those forms of standing to press those claims or those harms.
In fact, the implication is that you still have standing when you emerge with your constitutional claim in your pocket at the federal circuit.
Sure.
And so you're going through a narrow process, but and I'll go back and read Elgin about whether it talks about standing, but I don't
think Elgin had the unusual feature of this case where there was an organizational plaintiff attempting to challenge broader facets of an agency action, or we would say separate agency actions, that it would lack standing to challenge if those were channeled. I do think as to what comes out the other end, I think individual plaintiffs before the MSPB would likely be arguing, and maybe arguing already, that their termination was unlawful because it proceeded from this hypothesized singular decision to shut down the agency, and that decision was unlawful. I think they would be pressing that argument, and I think that emerges from the other side of the administrative review process. And I think the unions would be pressing the same kinds of claims through
from the other side, where then they could go to the federal circuit if they're saying, no, there was a RIF and you were discharged, done, and then they could go to the federal circuit and say, hey, wait a minute, this RIF was only a building block in a big illegal takedown that the president lacks the authority to do. This is an agency created by Congress. So you're saying that you would have standing within the federal circuit to raise those.
I think that's right. I think that would be a substantive ground of relief that they could press for their claimed unlawful discharge, and that would emerge even if the MSPB concluded that it wasn't able to review the Constitution.
We've been talking a lot about the employee claims in the unions, and channeling naturally comes up with those.
Sure.
If we just for 1 second, we can get back to that too, but for Oxfam, I know your argument is that Oxfam lacks standing. Suppose that Oxfam has standing, then is there a channeling issue?
So to the extent Oxfam was seeking redress in the form of undoing federal personnel actions, those would be channeled. Oxfam, of course, can't participate in the process. So that just means that they're in the position of the milk handlers in Block v. Community Nutrition Institute who were excluded from the administrative process. And that meant that they were not able to bring those claims at all. So we think those claims are channeled, meaning that Oxfam can't raise them in district court or otherwise.
So it's like Fausto. I mean, you think that Oxfam is hypothetically within the zone, but then actually what the result that Congress intended was that they just don't have any claim at all?
I think that's right. To the extent that they think they would have standing to challenge federal employment actions, you can't sort of abstract enough levels away that someone who's...
They're not saying they're complaining about federal employment actions. They're saying they're complaining about the fact that they can't do their relief work anymore because their relief work is impinged upon by the non-existence of USAID as a partner.
And I'm not meaning to fight the hypothetical. So two pieces of my answer. One, to the extent they're challenging grant terminations, we would have all of our channeling arguments about grant terminations. Otherwise, if they have a claim, if they have standing to challenge this hypothetical decision to close USAID entirely, then we would not have a channeling action to the extent that doesn't challenge either grant terminations or federal personnel actions. So they couldn't receive those forms of relief.
Are you saying that nobody has standing to challenge the dismantling of an agency in violation of the APA and the Constitution. Nobody has standing to just to challenge just the whole thing.
So I think certainly none of the parties before the court have established standing. That's our
But it
position.
just sounds like your methodology would reduce this to a series of actions and nobody would have standing to challenge all of it.
So
Is that the upshot of what you're saying, that nobody has standing to challenge the shutdown of an agency?
I do have trouble thinking of who would be the perfectly situated plaintiff whose claims aren't channeled
How about
because
not perfectly situated? Anybody? Could anybody challenge the
I have trouble.
constitutional dismantling of an agency?
I have trouble thinking of who that would be. I think for a lot of agencies, you might think that that would be an end user of the agency's services whose claims would not be
But
channeled.
they only use certain services, so they probably couldn't challenge other aspects.
I think the appropriate relief in one of those cases would be an order that says the agency needs to provide that. I think it's not, I'm not sure as a factual matter if USAID has actual end users other than grant
It
recipients.
seems to me that many of these cases that we're looking at, the injury is quite specific, but they're challenging larger action. Like free enterprise, it started with a company didn't like a report that was issued against it and didn't like an investigation against it, but then they challenged this much broader thing, the whole agency. And it just seemed to me methodologically, what you're proposing is unusual, and what Judge Nichols did was unusual. It seems to me that the more conventional way to look at this is kind of the way your friend on the other side said it. You look at the claim that was brought. Here, the claim is there's been a dismantling of the agency in violation of the APA and the Constitution and statute. Did that agency action injure the plaintiff? They say, yes, we lost our jobs. And would that injury be redressed if we set aside or enjoined the unlawful action? Yes, it would, because the agency wouldn't be dismantled and you would get your jobs back. That seems like a conventional view of standing. But what you're saying is we don't look at the claim brought by the plaintiffs. We look at the injury they experienced. And that injury is related to RIFs or losing their jobs. And then they have standing only to address that aspect. So we're going to rewrite their claim. Their claim is no longer a challenge to the dismantling of the agency. Their claim is now only a challenge to the RIFs or the employment actions. And this rewritten claim that the court has chosen for the plaintiffs has to be channeled. That just strikes me as a very unusual way to approach standing and inconsistent with the way standing. We have a lot of case law on standing. This seems inconsistent. And when you look at Judge Nichols's opinion, he doesn't rely on much. I just don't see what we're relying on here to do this very unconventional thing that Judge Nichols has done.
So a couple of responses. One, I think a fair number of my responses go to my earlier discussion with Judge Pillard about how this is an unusual case where we have.
But it's not unusual because in all of these cases, like Free Enterprise Fund, they're looking at, one small thing that happened to this company, but they're challenging a much broader action. In PETA, they're looking at, we're not getting information, but we're challenging like a whole regulatory thing. Like it's very common for the injury to be specific, but the claim to be broad.
I think the missing piece of that. So one, I think it's very normal to look at what the injury is in standing analysis. That's of course the first step. And so the claim is not the right framing for the first step of the standing inquiry. It really does look at the injury.
Whether you're injured by the alleged agency action, normally we take the plaintiffs to be the master of their complaint. Their complaint says there's been the dismantling of an agency. But we have a district court that says that's not your complaint. That's not your injury. That's not your claim. Your claim is different. Your claim is about employment and it needs to be channeled.
Sure. And the thing that I think is unusual about this case is that all of the injuries are the exact kinds of things seeking relief from employment actions. All of the concrete legally protected interests that the plaintiffs are asserting, setting aside Oxfam, are the exact things that Congress has channeled to an exclusive review regime.
That may be true, but that's not the claim that they brought. They brought a different claim. They filed a complaint saying you've dismantled an agency in violation of the APA and the Constitution and statute.
And so once those injuries are subtracted, as Congress has said they must be, because they have to go through this administrative process, Our only argument on standing is that they don't have legally protected interests that have been invaded otherwise, once those have been removed. And so there's nothing that allows them to stay in district court. At that point, they lack standing once these employment-related injuries have been channeled out as they have to be. I think the other piece is that
So assuming that somebody could have standing to challenge a dismantling of an entire agency, you're saying even in the context of a lawsuit like that, you couldn't challenge this aspect of the dismantling. It would have, that part of the entire claim would have to be, I guess this is your answer to the Chief Judge's question, that would have to be channeled.
that's right. Yeah.
But I thought you said that when you come out the other end into federal court and into a forum that has the authority to decide the issue, you would have standing to press your claim to the action that was not an action that the MSPB was authorized to
Right.
have.
That's the end of the channel. Once you get to the destination of
So
the channel.
it's not really a standing inquiry because first of all, you don't need standing for MSPB. You do need standing for court. And in court, they have standing.
Well, they don't have standing in the district court. I think that's our point.
Well, they don't have I think if you lose on the jurisdictional argument, I was reading.
No, I think you're
you
right.
hadn't cited the Friends of Animals. I was the Bernhardt case. I was just looking at that, but refreshed on that. I missed a couple of beats and maybe I'm stepping into it as a result, but I thought you answered me by saying that you wouldn't have standing in district court because it's channeled. And I thought, well, actually, isn't that really just that the district court wouldn't have jurisdiction? You have to be channeled. But then when you are properly in federal court, as is contemplated under the CSRA, you would have standing to bring the very claims that plaintiffs claim to have standing to bring in district court now.
I'm puzzling through whether I disagree with that or whether any conceptual disagreements matter. I don't think the district court did anything wrong by saying, where does their standing come from? All of their injuries are employment related. All of those claims, any claims arising from those injuries have to go through the channeling process. And because that's all they're asserting, there's nothing else for me to do here. I'm not sure if it matters conceptually, whether you think of all of that as happening under channeling or whether you think of that as standing plus channeling.
I think it matters a lot because if it's standing, then it wouldn't, I agree with the answer that you gave, I think to me and to Judge Pan, which is that you would have standing in the federal circuit to raise the claim that is the claim about the shutting down as contrary to the APA.
I think this is the same answer. I don't think they're losing any claims by being channeled first to the FLRA or MSPB or foreign service equivalents. I think everything will emerge at the end of that channeling process.
And you don't think that if there were no channeling, that these plaintiffs would lack standing to challenge the dismantling of the USAID?
I think you're limiting that question to the union plaintiffs.
If there were no channeling, if Supreme Court overruled Elgin and just channeling is a bad idea. We don't want to mess with these agency adjudicators. They're neither sufficiently accountable nor sufficiently independent. Let's just have more federal court action. If we were in that world, you wouldn't be making the standing argument that you're making here.
So I think we wouldn't be making a standing argument if absent channeling.
Okay.
I think we might still disagree about the proper scope of remedy, but that wouldn't be a threshold jurisdictional question. So I don't want to suggest that I'm agreeing that in order.
That makes sense to me.
Yeah.
But the upshot of, I think, Judge Pillard's line of questioning is that so the channeling is a jurisdictional issue that is separate from standing. And if your position is that after you're channeled, you would have standing to raise the dismantling of the agency, the whole constitutional and APA claim before the federal circuit, the question is, why would you have standing at that stage of the process, but not at this stage of the process? Just standing, putting channeling aside.
Right. And I think I disagree with the premise that they're separate. I think they interact a lot in this case because.
Well, the analysis is different. Standing is, do you have injury to, all of the rules of standing to stand before a court making this claim? Whereas channeling is this a type of claim that needs to go to a different forum, analytically separate and distinct? So if you agree with Judge Pillard that at the end of the channeling process, there would be standing, like you could bring those claims before the federal circuit, challenging the dismantling of the whole agency, why is there no standing now?
So a couple responses. One, first, this is in the hypothetical world where there was an actual agency decision, singular decision to shut down the whole agency,
you're
which we of
fighting
course disagree.
hypothetical,
Yeah, and
but
I just
let's
wanted
put that aside.
I just wanted to make sure that was clear as a premise of my answer. Two, I think, of course, I agree, separate analytical frameworks, but I think they speak to each other in this case. And so Judge Nichols' reasoning, which I think is right, was we have to look at what their injuries are. That's step one of the standing process. Channeling tells us at that step, we can't look at the injuries that are channeled because they don't belong in this court at all. And so they can't be a basis for injuries that are being
This answers
asserted.
the question of why they're standing at the end of the channeling process, but no standing now.
I think because it's a analysis that the district court had to undertake. And you can think of it in either direction. Maybe it will be clearer
But
if I say it in the other
isn't it the
direction.
same analysis the federal circuit would have to make as what we're making now, or what the district court had to make?
I don't think it would be the same analysis because the federal circuit would have a menu of all possible injuries to choose from. So there would definitely be an injury in fact.
Because there's no, your theory is at the federal circuit, there's no question about whether some part of the injury has to be channeled away to some other court from the federal circuit.
That's right.
The
They
federal
don't,
circuit is the recipient channeling court, not the sending channeling.
right. The
So-
federal circuit doesn't have to subtract anything out because it's being channeled elsewhere.
So you think it's kind of, there's this kind of sequential way to do this, that you start with standing, you look at injury, but then in looking at injury, the next step in the sequence is you do channeling to figure out, is there part of the injury that has to be channeled? And then you ask, if that does have to be channeled, then you discount that from what's left of injury.
So
Then you look at what's left of injury and you see if that independently supports proceeding in the sending court.
yeah, so I think that's perfectly sensible. I've also thought about it in reverse, where you first do the channeling analysis and then you ask if anything is left. I think either way you get to the same result, which is there are no injuries that can be pressed in the district court at this point.
Mhm.
I wanted to ask you the question that we asked you prepared to address an argument about RIFs.
Thank you, Your Honor. I'll start with section 7512B, which says that this subchapter does not apply to a reduction in force action under 3502. This subchapter is 7511 through 7515. That does not include the channeling provision, which is 7701. So the channeling provision, the upshot is the CSRA left to OPM an on-off switch about whether RIFs could be subject to review in the MSPB or not. But 7512B makes clear, because it's limited to a specific subchapter of the CSRA, that RIFs were very much one of the federal personnel actions that Congress was thinking about when it enacted the CSRA. And so to the extent OPM decides to flip the switch to off, which to my knowledge has never happened, of course, I know there's a pending regulation, but if they decided to switch it to off, that would place RIFs in the same category as the non-preference eligible accepted employees in Fausto. They would simply be foreclosed from review through the administrative process, and that would mean that Congress intended to foreclose those claims.
Foreclosure review through the administrative process and in court. There would be no review at all.
That's right.
And so walk me through again, how you get that? Is it just Fausto?
So 7512B makes clear that Congress was thinking about RIFs when it was enacting the CSRA. So this is not something that was sort of beyond the scope of the CSRA in general. It was something that was very present on Congress's mind, and they made the choice to exclude RIFs from the coverage of specific procedures provided for in 7511 through 7515.
Excluded from channeling.
No, 7701 is the channeling provision, and 7703 provides for judicial review of the MSPB decisions. 7701 says you can bring a claim in the MSPB if it's provided for by statute or regulation. And that's what allows OPM to either channel it to the MSPB or say that there's no MSPB review and therefore no administrative process that would get you into the
regulation part of that.
Exactly, the regulation part of that. I'm happy to give one piece of nuance to this, which is that the longstanding position of the government since Elgin at minimum is that constitutional claims that cannot be brought through the administrative process could be brought directly in district court. So that would be my one caveat. I don't think that's implicated in this case because, of course, there is a regulation that provides for administrative review.
And that the constitutional part, that's Webster, that's,
That's right. That's the same position articulated in Elgin in the briefs.
my colleagues don't have additional questions for you. Thank you, counsel.
Thank you, Your Honor.
Ms. Golden, we'll give you 3 minutes for rebuttal.
Great. Just a few quick points, Your Honors. First, to pick up where my friend on the other side left off, I think that this is a situation that is distinguishable from Fausto. There, Congress had provided a scheme for some types of claims for a category of claims by some types of employees to bring claims before the MSPB. So the question there was whether it was fairly discernible that the Congress meant to preclude review for the same types of claims brought by different categories of individuals. And there, Congress looked at the intent of the statute and concluded the intent was to create a singular regime. This is different. Congress carved out RIFs for all employees, and there's nothing to suggest that meant that RIFs could not be challenged at all. And so there's nothing here to suggest that the intention there by precluding RIFs was to carve out RIFs from review entirely, and that doesn't make sense. RIFs speak to the structure of an agency, and so it seems that Congress would not have intended to prevent individuals from challenging RIFs altogether. Second, my friend on the other side talked repeatedly about how in channeling cases, you separate out the injury when looking at the channeling scheme. And I think Justice Barrett's concurrence in the recent NIH case is helpful here. There was a set of grant recipients who challenged both their termination of grants, but also the administrative policy that resulted in the terminations of their grants. And there, Justice Barrett, in her controlling concurrence, found that those claims dealing with the terminations directly should be channeled to the Court of Federal Claims, but that the APA claims could proceed in federal district court. And the injury there is going to still be the termination of grants, and she didn't suggest that you separate out that injury when looking at whether or not they could have brought those APA claims. And so I think that further supports that you shouldn't split up the injury here for these purposes. And then the last thing I'd like to note is my friend on the other side suggested that a potential individual or entity that could challenge the wholesale of the closure of the agency would be the end user of USAID services, and that's Oxfam. Oxfam relied on the services from the agency, the knowledge, the expertise, and so they should have standing here to challenge that closure. We would ask that the court reverse the district court decision and remand for further proceedings on the merits. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 25-5291, Personal Services Contractor Association Appellant versus Donald J. Trump, President of the United States of America et al. Ms. Shapiro for the appellant, Mr. Davis for the appellees.
Good afternoon, counsel. Ms. Shapiro, please proceed when you're ready.
Thank you, Your Honor. May it please the court. My name is Caroline Shapiro, and I represent the Plaintiff Appellant Personal Services Contractor Association. I'd like to reserve 3 minutes for rebuttal. This case arises from the same facts that you've just been discussing, many of the same underlying legal issues, and indeed, Judge Nichols wrote a single opinion. So as I've been listening to the argument from the other room, I do feel that I'm walking into the middle of a conversation. I will try to keep that in mind as we proceed. But the district court in this case made some of the same errors with respect to the PSCA as it made with respect to the unions, misapplying standing law. It artificially narrowed our injury, the actions we challenge, and our legal claims to individual contract-related job loss. Then it held that those claims had to be channeled by the Contract Disputes Act into a completely different administrative or a completely different dispute resolution regime from the CSRA that is analyzed under a completely different test from any of the channeling discussions related to the CSRA. Finally, it misstated and misapplied the preliminary injunction factors. All of this requires reversal. So I'll just start with standing and say, to begin with, as you have been discussing, one of the district court's errors here was to disregard what we alleged to be the agency action, which is the shutting down of USAID. That's in the very first paragraph of our amended complaint. And instead said, well, we're going to slice and dice all the different actions that were taken in order to implement that decision and require you to establish some kind of redressable injury with respect to each one of those underlying individual actions. That is put another way, what they said, what the district court and now the government accuse us of is kind of trying to lump together a bunch of things that are actually different decisions into one big challenge. But we are not the ones doing the lumping together. That's the government. The government made a decision to shut USAID. It said it was going to shut USAID, and it proceeded to take all the steps it took in order to shut USAID.
So in this kind of context, what's your perspective on how we should look at the relevant action to assess whether standing exists? And in particular, do we take at the dismissal stage, do we take the plaintiff's assertions in the complaint as to what the relevant action is as a given? Or do we not do that? Do we peel a layer away and look behind that in some way? What's your perspective?
Well, I would say generally on the motion to dismiss stage, you would accept the plaintiff's assertions. We're also at the preliminary injunction stage, and we've submitted extensive evidence to establish that this decision was made at a very high level, at a very early stage within the administration, and that it was never deviated from. There is, of course, the final mission email, which in our appendix is JA 259 to 63. That's dated March 28th. But there's lots of other evidence in the record dating back to early February to establish that defendants made this decision that USAID had to die. That's what Elon Musk said, for example. And that evidence is throughout the record that we've already created. So
I guess my question is less, was there such a decision in fact? Because that's something that's going to be determined. But for standing purposes, what do we assume the relevant action to be in judging whether the claim that's before us is one that ought to be channeled or not? Do we look to you're right, in your complaint at the first paragraph, you say that there's a dismantling of USAID. And if the complaint says that there's a dismantling of USAID, and if you ask, is a challenge to a dismantling of USAID something that gets channeled, you might have an instinct to have one particular answer. But if you don't take that as a given and you look and you say, no, you just can't just take that as a given, you got to ask, well, what actually visited the consequences being complained of upon the plaintiff? Then you might have a different frame of reference for how you decide whether something needs to be channeled. So
So can I separate the channelings for a minute from the
From
standing
Yeah,
question?
sure. Okay, sorry. Yeah. yeah.
No, but I understand the connection.
Yeah.
I think the standing question, I think, is answered very clearly by Collins versus Yellen. Collins versus Yellen says, look, where there's an injury that has been caused by something that the defendant did, the plaintiff could challenge that injury on any basis, any underlying legal basis. It doesn't have to be, it's not constrained by the nature of the injury. To put it, to quote, when it says, right, that the Article 3 standing requires only an injury traceable to the defendant's conduct, not to the provision of law that's challenged, and goes on to talk about how any injured plaintiff can bring a separation of powers or structural constitutional challenge. And in Collins, the actual injury was a pocketbook injury. The claim was that the people who made the decision that led to the pocketbook injury were unconstitutionally insulated from presidential removal. So I think the causal connection between our claim and our injury is actually much tighter than we saw in Collins. So I think you have to start there in thinking about whether or not they're standing.
Mm-hmm.
I would also add that there is also a kind of free enterprise axon here and now injury that's at play in these cases that I did not hear anybody talk about in the earlier argument. Part of the
Okay, so before we go to channeling, because that goes to channeling, right?
I think it goes to both, actually. I mean, free enterprise is a standing case, but
I thought you were talking about here and now.
I am.
Yeah.
But the injury that Axon said was important, that therefore shouldn't be channeled, was having these unconstitutional decision makers make the decisions about the plaintiffs. And that is, or the petitioners, that is also what's happening to us. There is an unconstitutional decision maker, the executive, deciding to dismantle a congressionally created agency and not to spend the money that Congress has appropriated on the things that Congress has directed it be spent on. So,
and when you say us, are you talking about the organization, or are you talking about the organization as emissary for the individuals?
both. I think.
And does the distinction matter?
I don't think the distinction matters in this case very much. I think associational standing is not even contested by the government in their briefs. It's clear that our members were injured by what happened. It's clear that the PSCA exists.
But then do you think that doesn't have the distinction between associational standing, the potential distinction between associational standing and organizational standing? You think it doesn't have any implications for this case, even with respect to channeling?
I think organizational, if you think there's not associational standing, which even the government essentially concedes that there is, so that our only form of standing is organizational standing. Let me rephrase that. If we have organizational standing, and I believe that we do, and I'm happy to talk more about that, that's an additional reason why it shouldn't be challenged, because the PSCA is not a contractor and has no ability to seek contract remedies under the CDA.
So that's what I'm wondering is, does the theory of standing, whether it's associational or organizational, affect the channeling inquiry? Do you think it matters for your purposes how whether channeling is required, whether the standing is premised on organizational standing or associational standing? Because it's sounding like you're saying, well, we would get home either way on channeling too, but we might have an easier time getting home on channeling if there's organizational standing as opposed to,
I think I would,
in addition to associational standing, or am I misunderstanding?
No, I think I would put it slightly differently. I would say we get home either way. There is no channeling, as I'm happy to talk about in a moment. We have one additional extra argument under organizational standing that we would add, but I don't think it actually makes our claim easier under organizational standing because it is so clear that we shouldn't be channeled in the first place.
So the extra argument. So, for example, just to put it more concretely, imagine that USAID is fully dismantled, but most of the personal service contractors that you represent, or let's say all of them, are rehired by the State Department. Is there a remaining organizational injury to your client? Not. If so, what is the organizational injury and how is it? What's the extra argument?
So the organizational injury goes in part to what happened when the USAID shutdown began. The PSCA, which had existed sort of internally as an employee interest organization, of course it's not a union, had managed its archives. It had managed its communication with its members, all on USAID platforms. It lost all of that with the shutdown. It's lost its archives. It had to recreate everything from scratch, essentially create a new website. And that those are pocketbook harms that still, I think, provide standing regardless of whether all members are rehired by a different department.
I'm not sure I fully follow that, because if the association exists to support an institution that exists, meaning USAID, and then that institution doesn't exist anymore, then the fact that you don't have the archives, why does it matter? Because there's nothing to support anymore.
The institution, the organization exists to support the PSCs.
Right.
Who work at USAID and exist to represent the interests of now former PSCs as well. So it is continuing to serve that attempt to fulfill that part of its mission, which has been impaired by the shutdown of USAID.
Let's suppose the shutdown of USAID, of course you resist this, but let's suppose the shutdown of USAID is fine as a legal matter. Then what interest does the association have with respect to former PSCs?
I think the organization, well, of course I resist the hypothetical.
Absolutely.
It may very well have an interest in assisting former PSCs and continuing to find work in the humanitarian sector, in negotiating, in networking, to the extent that they do go work for other parts of the government, with respect to how that might interact with their prior work. We haven't developed the record on that particular point, but those are some of the several ways I could imagine the PSCA would continue to have an interest.
And the shutdown of USAID affects that continuing interest because there's
they've lost all of
resource
their
materials
yes.
that otherwise would be available that
yes.
have been lost. Mm.
So with respect to the interaction between channeling and standing, the Chief Judge asked you, does it matter whether it's organizational versus associational for channeling purposes? And it seems to me, regardless of the theory of standing, if a case gets channeled, your client is still a union that has no contract, and therefore
we're an association with no contract.
An association with no contract.
Yes.
And
so
we have regardless of the theory, right? You just don't have a contract to enforce before.
We cannot go to the CDA.
Yeah.
Excuse me, to the
CFC.
To the CFC.
Under the CDA.
Right, under any theory of standing.
Regardless of the standing.
Correct. Mm-hmm. So I'll say a word about channeling unless there are further questions on standing. All right. Well, so first of all, I just want to reiterate that the channeling analysis for the CDA is completely different from the channeling analysis for the CSRA for many reasons. But there is clear precedent in this circuit as to how to determine when the CDA channels some claims, and that's Megapulse. Megapulse says very clearly that you look to two things. First, the essence of the claim a contractual claim? That is, what is the source of the rights? And second, does the plaintiff seek contract-like remedies? So we neither of those tests are met here. Our claims have nothing to do with contracts. Our claims have nothing to do with the enforcement of any individual contract. They have to do with the Constitution and the APA. Nor do we seek contract-type remedies. The district court suggested that the only remedy we could get would be a contract-type remedy of reinstatement, but that's not what we seek. We are seeking compliance with the Constitution and the law.
Can I just on that score? So you are seeking other things too, but in the complaint, in the amended complaint, there is in the prayer for relief a request for restraining defendants from enforcing and giving effect to termination notices sent to USAID personal services contractors.
Yes.
So that piece of it at least sounds in reinstatement.
It sounds in reinstatement, but it is conditional. It was conditional on the government coming in and saying, well, we're not going to shut down USAID, and here's how we're going to do it. I mean, at the point that we filed our amended complaint, PSCs were still employed. They were getting their notices, but they were still employed, and we were trying to preserve the status quo ante at that time. The government could have come in and said, oh, you're right. We can't shut down USAID. We don't have the authority to do that. Here's how we're going to proceed. And that would have mooted that particular request for relief because it was entirely conditional on USAID continuing in our attempt to preserve the status quo ante.
So you mentioned the Megapulse analysis, but we also have this Ingersoll-Rand analysis. If the question presented by the complaint could be phrased as whether the contract forbids termination under these conditions, then it's likely an action founded on the contract. I mean, it seems like it's at least possible to look at this suit that you're complaining about terminations of contract for unlawful reasons. In other words, shutting down USAID. And so under Ingersoll-Rand, your claim would be channeled.
Well, I think it's important to see Ingersoll-Rand in the context of what the CDA does and what it was created to do. What the CDA does is it says, look, when there are disputes between contractors and the government, what we want is for them to go to their contracting officer and try to resolve the dispute. And if they can't resolve the dispute, then there's this review process, either in the CFCA or the agency board, CFC or the agency board. And in Ingersoll-Rand, the issue there, right, was whether the particular contract could be terminated and rebid, and it had to do with the application of the FAR, but it was all very detailed, nitty-gritty stuff about how contracting operates. That's got nothing to do with this case. This case is about massive constitutional questions, and the idea that the first step would be to go to a contracting officer and say to a contracting officer, give me a written opinion about whether the agency that you work for can be shut down. It seems completely outside the realm of what a contracting officer's expertise is, and then, of course, the CFC or agency board's expertise. It also seems, frankly, kind of silly. I mean, it is the kind of thing that in Axon, Justice Kagan said, it just beggars belief that these kinds of fundamental, even existential questions would be channeled in that case to a different kind of agency. But she was the court was very clear in that case that those kinds of large questions, it matters what the expertise of the agency is, that it would be channeled to. It matters whether. But the bottom line is, do we really think that's what Congress was trying to do? And in fact, what is pretty clear what Congress was trying to do with the CDA was rationalize what was a pretty chaotic system of contractors dealing with different agencies. Really, and that I think is what Ingersoll-Rand speaks to.
So you also said that we should remand to the district court to reassess in light of changed conditions because the dismantling of USAID has continued since this record was compiled. Can you fill us in at all on, I mean, I know the record is the record, but just for our situational awareness, what the current conditions are? Have all the PSCs been terminated? Have any of them been rehired by state? Are there other
I believe that all the PSCs have been terminated. I believe that some PSCs have found work in other parts of the government. Many have not. Many have not been able to find work in the humanitarian sector at all because the USAID shutdown had these much larger ramifications. It wasn't just a regular employment decision. It actually devastated the entire sector. There are a very small number of employees still at USAID who are currently working, as I understand it, and again, this is not in the record, but as I understand it, they are working to wind down the remains of the agency.
So are those folks who have to deal with like accounting or management or IT or that kind of thing?
I don't have enough information to be able to really describe what I think they're doing. But it's my understanding is that they are winding down.
And when you say some have found work elsewhere in the government, your sense is that that's not in international development work.
I mean, there are 1,400 PSCs. I don't think I can represent to you what they have all ended up doing, or even what any particular proportion have ended up doing. I do know that some have not found work. Some have not found work in the humanitarian sector. And so that would have to be developed, which I'm sure we would be able to do.
So on irreparable harm, it's, where the injury, for example, is termination of employment, it's really hard to demonstrate irreparable harm. And you argue in your brief that, and this is sort of related to what you were just talking about, that the PSCs, many of them will not be able to continue in their careers because, as you mentioned, USAID is such a major sectoral player. And I wonder if they're in the existing record, which I understand is dated in some important ways, anything that we could rely on to assess whether that point is supported. You have this argument, the Humpty Dumpty argument, that once it's taken apart, it can't be put back together again. It seems like we're sort of Humpty Dumpty's down off the wall now.
Right. So I have a couple of answers to that question. First, there is no question that some of the irreparable harm that we warned about in our filings in the district court have come to pass and are indeed irreparable. But the irreparable harm is ongoing. And some of it can still be stopped. It might be harder to put an agency back together than it would have been at the time that we originally filed. But that doesn't mean that there aren't things that the court can do to require compliance with the law, to require compliance that USAID continue to be an independent establishment as Congress required, and that it, as part of that it have the ability to continue to just to obligate and spend and oversee the money and the programs that Congress has given it the responsibility to do. So there are still things to be done. They may be less effective or more cumbersome in many ways than it would have been a year ago, but the case is we certainly would not say that the irreparable harm is just over and done and in the past. It continues to be ongoing.
I'm sure my colleagues don't have additional questions for you this time. Thank you. We'll give you some time for rebuttal.
Thank you.
Mr. Davis.
May it please the court, Tiberius Davis on behalf of the United States. This case is even easier than the one you just heard about because the district court denied a preliminary injunction sought well over a year ago, and that was not an abuse of discretion. Plaintiff seems to admit at reply brief 6 that their injuries all stem from the termination of the contracts and the loss of their members' employment. Yet they seek standing and relief that would reorganize and restructure the entirety of USAID without ever connecting the injuries to that redress. That is a problem for standing. It is also a problem for channeling. They don't get to attempt to artfully plead around that standing issue or the channeling issue by claiming constitutional or statutory claims under the APA. And Judge Pillard, unlike your dissent in Vought or in the Lake decision, there were no factual findings of a single agency action here. There was a record on the PI, and Judge Nichols ably explained why the different actions should be disaggregated for standing purposes. Now, the one claim that plaintiff might have to bring is related to the contracts that were terminated that injured their members. But the Contracts Dispute Act is Congress's attempt to channel implied and express contracts for personnel services through a particular mechanism through the Court of Claims. They've never denied that the contracts at issue that were terminated and that thus injured their members are those types of contracts. And even if they had constitutional claims, the Supreme Court in Elgin and NIH has channeled claims brought under the Constitution and the APA. This court in AFGE 2 has done the same. The First Circuit recently in Sustainability Institute has also done the same. There's no reason to divert from that. So I think, but even if this court disagrees with us on the likelihood of standing and the likelihood of jurisdiction, the district court also found a lack of irreparable harm based on the employment-related injuries under Sampson versus Murray. We don't think that that is an abuse of discretion. That alone is a basis to affirm the district court. But even if the court disagrees with all of that, we think the proper relief here would be to remand for a determination on the rest of the likelihood of the merits. And given the fact, and I think plaintiff agrees with this, that there's been a year and a half of changes to remand on the equities and irreparable harm. But at bottom, we think Judge Nichols' careful opinion correctly disaggregated the injuries and the conduct at issue and found no likelihood of standing and no jurisdiction. So briefly on the standing point, they tried to say that we narrowed their injury to just terminations. If you look at reply brief 6, that's what they say the injury to their members are. It is the loss of employment. On the organizational, I believe it's page 36 of their brief, they don't even really say what their injury is. I think arguably that's waived. And in reply, what they talk about are these past injuries of difficulty contacting members and having to sort of provide them support. It's not apparent that those are ongoing. And they also say, well, we might stop existing. I heard them up here today indicate that they haven't stopped existing, but even so, that injury goes back to their members losing their jobs. Everything they talked about goes back to their members losing their jobs and sort of the kick-on effects of that. And I don't think just because they're an association, and this is to sort of some of Judge Pan's questions, that just because they're association and not the actual members that they get out of the channeling. I think AFGE 1 makes very clear there a union was trying to bring claims, and this court said, you know, just because you don't have any claims that you could bring under the channeling, that just means Congress didn't want you to bring the claims at all. And I think that's the case here for PSCA. Now, obviously, their members can, and I think have brought some claims.
What about the theory you heard earlier in the argument that the shutdown of the agency, this goes to standing and organizational standing, the shutdown of the agency caused there to be the unavailability of resources of a data bank that would enable the association to help, for example, former PSCs find employment, things of that nature. And that's harms the organization, qua organization, and it results directly from the shutdown.
I think 2 responses to that, Your Honor. 1, I didn't see that in their briefs. And frankly, I was looking through some of the stuff below and I didn't see that argument either. So I think that that's waived. Second, I think that would be an informational injury that they haven't argued here. And I think there's no statute requiring that. So I think they would have a hard time with the informational injury. And third, if that is something that
I don't know if it's an informational injury as such, because it's not information that the agency, whether required or not. I mean, I know that you could try to tether it to a statutory mandate to supply information, but it's not that there's a requirement to supply information. It's just that there's just a store of data that just exists and now it's gone.
I'm not sure. I mean, it does seem like they want access to that database for the information inside of it. And it seems weird that they would have additional standing in the absence of a statute mandating it. That seems kind of odd to me.
But because their claim is different. The claim is not like a FOIA claim. It's not a claim to information. It's a claim challenging the shutdown of the agency. And one of the ways that harmed them is it took away something that belonged to them. Which was whether it's information or whether it's, a box of money or it took away something that belonged to them. And so I don't think you have to go through the right to information analysis in that, where that's the role that the loss of information is playing as injury in fact.
I'm not sure I agree with that, but even so, again, I don't think they made that argument and here or below. So I think that's waived. I think even if they did, then their injury would be to that precise conduct and they might have standing to challenge that. But I don't think that would be standing to take down the entire restructuring.
And we talked about this in the last argument, this question about the relationship between the injury and the framing of the claim. Plaintiffs argue that the contract terminations, that the loss of their informational resources those are the injury that provide them with standing to raise a claim that is not a claim of contract breach. It's a claim of unlawfully shutting down USAID. And to rule on that claim, we don't need to interpret the contracts. We don't really even need to look at them. If we believe that they were PSCs and they've alleged that they've been let go, then we can evaluate a statutory or constitutional question. So I guess I'm asking you some of the same questions that I asked Ms. Welch. What is your authority for the notion that a different claim that might respond differently to the injury in fact that they assert in support of their standing is now, we should treat that as the claim that's being pursued and the only claim that may be pursued?
So I take that to mostly be a standing question, although there were some channeling pieces to it. My colleagues sort of stole some of my thunder with the Friends of Animals versus Bernhardt. I think they were challenging a single memo there, sort of like the final mission email they're pointing to here, saying that's evidence of this sort of single agency action. And the court at the standing inquiry said, no, there are discrete effects, discrete actions here. I think that's the exact same here. The RIF.
So different though. Friends of Animals versus Bernhardt and CBD are cases in which so in Friends of Animals, the agency used to do sort of species-wide determinations about whether hunting would be advantageous or not. And they decided to change the way they did business. And they no longer did a notice and comment general rulemaking. They said, we're just going to do individual permit applications by adjudication. We're going to look at the information we had before, but we're just going to do individual permit applications. And the plaintiffs wanted to say, you have to do this you have to do this in a big package. And the agency says, no, we don't. And that seems right. And that's just like in CBD, where what the plaintiffs were saying is we want to challenge a whole aggregate of permitting for wells. But the unit of decision in both cases that the government had landed on was the well or the safari permit, or the take, of the wildlife, not a larger thing. It wasn't like you've closed the entire safari program to us, or, there wasn't an action. And here it's very different. The government has decided on their allegations, and that's where we are at now. The government has decided we don't want to have AID as a freestanding. We want to do international aid in a different way in the State Department. That's the action. So I don't see in either of those decisions any authority for the idea that the court remakes the claim from something different from the unit that the government has done. The government in those cases has said, we're doing permit by permit, we're doing well by well. That's not what the government did here. It didn't say, we're only looking at each PSC and deciding who's good for us in the new world. That's not what they did.
I think a lot of responses to that, Your Honor. First, I think that's sort of intermingles final agency action with standing. I think it's sort of a weird question about how that works, but that does seem to be something that happens.
But the action, assume final action and assume it is the takedown of the agency. And I know you may dispute that on the merits. That's not where we're at.
We are. It's a preliminary injunction.
Well, I'm asking about pleading and the claim.
But that's not
standing to bring the claim.
That's not on appeal. This was a denial of preliminary injunction for likelihood that they do not have standing. So I think that's different.
Okay,
that's first.
Well, so on the preliminary injunction, they say evidence showing this intent to take the agency down, we're being harmed. And where is the authority for the court having to change the aperture? Like, you claim you're bringing an APA constitutional claim, but you're not, because you're contractors. And one of the components of the action that you've identified is termination of contracts. What is authority for that? I mean, when there's a challenge to remain in Mexico, you don't see the court saying, well, you sent a bunch of agents out and you had to, bring a bunch of, staff away from where they used to process people in Mexico. I mean, you don't break it down.
I think I just fundamentally disagree with you, Judge Pillar, because I do think
I want to know why.
So because I think Friends of Animals versus Bernhard, they were saying, we think this change in how the agency is going about this is an agency action that we're challenging. I think in Lujan, this is at 568 of Lujan, the 1992 decision, they said that respondents also failed to demonstrate redressibility. Instead of attacking the separate decisions to fund particular projects allegedly causing them harm, respondents chose to challenge a more generalized level of government action. So again, in both Friends of Animals and Lujan, the plaintiffs were trying to say, well, there's this higher level of government action, and we're challenging that government action under the APA. And the court said, no, we can break that down and see where there's redress. And I think that's the exact same here.
It sounded like the problem was that if they took the challenge to the higher level action as a given and just said that as a consequence of that, redressibility is hard to show.
And I think that's part of what we're showing. Well, they said they're not redressable by the whole thing. But
right, exactly. But it took the unit, to use Judge Pillard's nomenclature. It sounds like from that passage, and I haven't gone back and looked at exactly at that, but just the way you recited it, it sounded like it took that unit as a given and said, therefore, there could be a redressibility problem, which could be true. But it didn't then say, no, that's not the relevant unit. The relevant unit actually is a lower level.
No, that is what the court says. It then says, this programmatic approach has obvious practical advantages, but also obvious difficulties insofar of proof of causation and redressibility. As we have said in other contexts, suits challenging not specifically identifiable government violations of law, but the particular program agencies established to carry out their legal obligations, or even within premise on allegations of several instances of violations of law, are rarely, if ever, appropriate for judicial adjudication. So I do think that the courts can break them down permissibly. And I think to the extent this overlaps with final agency action, we think the state panel's decision in Lake and the panel decision from Vought were compelling. And to Judge Pillard, I know you dissented in both of those cases, but I took a main thrust of your dissents in those cases to be, there was fact finding there. There was a lot of evidentiary hearings saying, well, we're looking at all of these pieces of evidence and we're saying, based in the district court was saying, based on clearly erroneous review, I think that there was a single agency action. And that's a big part of your dissents there. But here, this is preliminary injunction. There could be evidentiary determinations, but the district court didn't do that. It didn't say that there was a single agency action. Instead, it broke them apart. So I think on the PI standard, and especially given that, you can break them apart. And I think, we obviously disagree that there's a single agency action. We fought that below. PSCs, for example, a majority of them were actually terminated in early February, and then others were terminated later in March 28th. So I think we can, quibble about that. But I do think that goes to standing. And then I also think the question of can we reframe their claims goes a little bit more to channeling, because that happens quite often in the channeling realm. In both AFGEs, they were bringing APA statutory claims. In AFGE 2, which Judge Srinivasan, you were on, they were making constitutional and First Amendment claims. Those were channeled. AHUJA, Judge Pillard, similar thing there. I think if you look at the Supreme Court, I'm a little bit surprised that the other side is relying on NIH, because NIH at the jurisdictional stage, because this was about channeling, Judge Barrett split apart the guidance and the actual terminations of the grants. And even though for both of them, they were bringing APA claims, including constitutional APA claims, the court, Judge Barrett said, well, you can look at the guidance, but the grant terminations, those still have to be channeled. I think it's the exact same analysis here. I think Ingersoll Rand makes that clear, that just because you're sort of bringing a regulatory or statutory version of their claims doesn't mean that doesn't get channeled. The other side talked a little bit about the type of relief at issue here. And I think Chief Judge Srinivasan, you were right to point out that even in their amended complaint, they were asking for reinstatement. And now they're trying to say, no, we just want compliance with the statutes, with the Constitution. But if you look at their PI, they still ask for reinstatement of the PSCs. Now they say that's contingent on them the agency following the Constitution and the laws, but that's sort of the nature of the PI, is that it's contingent it's sort of in place preliminarily until they're sort of full compliance. So I think that is actually, at the end of the day, the redress that they are seeking. And if that's not the redress they're seeking, then I think that's a real standing problem. How does it redress the injuries of their members and of the organization if they're not even asking for back pay or reinstatement for their members? If it's just the agency can do something else, like only, let's say in the previous case, they just bring back all the direct hires and don't do anything with the PSCs.
But I think it's likelihood, right? At this stage.
It is.
And so, I mean, if the agency gets reconstituted, then court would have to make an assessment of whether it's likely that there would be something of benefit in that to the personal service.
But I think at the PI stage, likelihood of redress is a standing requirement, a burden that plaintiffs bear. And I don't think that they've shown that what they're asking for would have that. And I also think it's worth noting that in neither of their complaints, or obviously in the preliminary injunction that's on appeal, have they asked for vacatur of a single agency decision. They've only been seeking injunctive relief. And I think there's going to be a real CASA issue there too, which I think has some overlap with the standing problems.
Can I ask one conceptual question about the relationship between the nature of the particular injury that's at issue and then the scope of the action? So in NTEU, the on-bank case, which you will be familiar with, the issue has to do with the alleged dismantling of another agency. And at the panel stage, at least, the standing, I think the panel was unanimous on standing. And the existence of standing was predicated on, and if this is too far in the weeds and you're not familiar with it, I'm not expecting you to be up to speed on this. But as I recall, the existence of standing was predicated on the NAACP wanting some information that was statutorily, I think it was a statutory mandate, if I'm remembering right, statutory mandate that the agency would disseminate, and that information was of use. Should that case then not have been about, if that's the reason for standing, should that case then have not have been about the dismantling of the agency? It should have been about something much narrower than that, if that's the injury that allowed the case to proceed? I
mean, I think so. And we do disagree with the panel's determination that there was standing
right.
for the whole thing
you
there.
Disagree on standing, but I never recalled an argument that even if we're wrong, we being the government, even if we're wrong about standing and standing exists for this reason, the scope of the dispute should be narrowed to just this.
I don't think we made that argument there. I do think, obviously, then the final agency action determination said these were all distinct final agency actions. And if that's sort of the unit by which we're measuring what the injury and what's caused by the injury, I don't see why, for the Friends of Animals and Luluhan reasons, why that wouldn't go to standing as well. So I think that it could be a standing issue there as well.
But that would be the upshot of your theory, is in that case, if that was the predicate for standing, then actually it shouldn't be a dismantling in the agency case. It should be only about the supply of this particular report.
I think that's right. And I think there could be situations, I believe my colleague talked about this, hard to imagine who it would be here, but there could be an end user who has multiple different types of injuries from different parts of a dismantling of the agency, and that they might have standing to bring a lot more things. But again, I think there is an aspect of they were seeking vacatur. Here in neither of the complaints or the PI are they seeking vacatur or anything like that. It's all equitable. So that gets back to sort of the CASA point. And then, the other side relies a lot on these separation of powers cases. They rely a lot on Collins. I'm still kind of surprised by that. I think Collins, frankly, helps us. So the court was very brief in discussing standing there. And it said, well, these shareholders, they have a pocketbook injury. That pocketbook injury, they said, was caused by the amendment. And essentially enjoining or undoing that amendment would give them redress. And the reason that they could challenge the amendment was because the directors had this unconstitutional removal protection. But they didn't say that means you can challenge everything that director did or that you could take the director away. And in fact, when you get down to remedy, the court was very, very careful to say, well, this is really the only type of relief you could possibly seek. And even then, we're going to remand for the district court to determine whether or not the president would have removed these people but for. So I think that really shows that the injury and
that's about remedy at the end of the day.
That is, but the standing, I think it's narrowed to the injury of the pocketbook injury caused by the amendment. And the reason the amendment was unconstitutional and that they could challenge it was based on this separation of powers issue. But the actual injury and the cause of it was from the amendment and the pocketbook injury. And I think that's very similar here. The actual injury is the loss of their jobs. That was caused by the termination of their PSCs. And, are seeking reinstatement, and that gets channeled through the CDA. And I think, obviously, as your honors know, the CDA has channeled before constitutional claims, statutory claims. AFGE, those are CSRA cases, but similar principle. I think California and NIH sort of show that too from the Supreme Court, that these sorts of channelings are common here. And obviously it can go to the court of the federal circuit at the end of the day. So I don't see any problem with channeling here. They focused on Axon and said that this is a similar here and now injury. I don't really get that because Axon was the process they had to go through themselves. They were saying was unconstitutional. And Justice Kagan's point for the majority was, well, once that's completed, you've been injured and then there's nothing else to do. It's almost like it would be moot at that point. Clearly, they don't think even absent the PI, this case is moot. They think it should keep going. And it's not the process that is the injury here. It's, all the sorts of agency actions. And they, one thing we haven't talked about in any of the cases,
It is the they're bringing a separation of powers claim. They're saying that, Congress created this entity, approved it, passed legislation, riders saying that it shouldn't be reorganized without consultation, and made multiple appropriations for specific purposes. And that if the executive takes it down contrary to all of that, it's both statutory and constitutional violations that maybe they can't be undone. It's looking harder and harder.
So I think a couple of response to that, Your Honor. We obviously disagree that we violate any statutes, but we can put the merits to the side. We did argue here, and we think it's correct, that what they're bringing are fundamentally statutory claims. They can't bring the separation of power claims.
If they're statutory claims, they're claims that are major structural claims, and it is harder and harder to undo them, is it not?
I think that cuts against them getting a PI for the equities and for irreparable harm
because the closing the barn door after the horse is out.
So obviously we disagree that the agency is fully shut down. Isn't independent anymore.
If it were, is there no role for a PI?
I don't think that a PI, the point of a PI is there's irreparable harm. We're trying to stop it for the status quo now. It's been almost a year and a half then, and quite a few differences. I think that question, if the court disagrees with the district court, which we think that's abuse of discretion, it should affirm. I think the Sampson versus Murray and the district court's analysis there is correct. But if the court disagrees, I think it should remand on that question to see if there's anything else being done that would make it different.
Any information at all? I know it's off the record and, we won't hold you to it, but just any for our situational awareness, what's going on? People being reemployed at state, programs being stood up, money being actually spent?
So my understanding is there are under state, and we can get into the Federal Assistance Act on this, but there are programs that still exist that are still being funded. Some people, I don't know the exact number, have been hired at state for similar jobs. USAID still is an independent agency and it still has employees. They're not doing a lot of the grant funding that they were doing before.
Any?
I'm not sure about any. Certainly a lot of that has been moved to state. And I think that that's well within the statute. If you look at the Federal Assistance Act, which is getting, more into the merits, but
I don't know that we need to delve.
Just a general sense, yeah. So your sense is that there is some uptake of some of the people.
That is my understanding, is that there is some uptake of some of the people, and there are certainly still programs and grants being funded. So, but I think at the end of the day, even if the court, again, disagrees with us on likelihood, and this is a PI, abuse of discretion, but if the court disagrees with us on likelihood of standing, on likelihood of jurisdiction, that they can still affirm purely on the lack of irreparable harm. And even if the court disagrees with that, we think it's most proper to remand so that the district court, given the year and a half almost change, about a year, over a year change, should re-examine irreparable harm, all the changes, the equities. I think even plaintiffs would agree with that, the scope of relief, things like that. But we do think the district court was right in its analysis here, and that the court should affirm the denial of the PI.
Make sure my colleagues don't have any additional questions for you. Thank you, counsel. Shapiro, we'll give you the 3 minutes.
Thank you. I'd first like to answer your question, Judge Pillard, about evidence in the record related to the humanitarian sector. If you look at JA 270 to 72 and 439 to 40, You'll see some unrebutted evidence in
I'm
declarations.
sorry, what was the second one?
For JA 439 to 440.
And the first one was 270 to 272?
Yes. I want to address just a couple of points. First, the point about Collins and the scope of remedy and what that has to do with standing, I think is actually crucially important. It has nothing to do with standing. And we can see that if we look at SELA law. In SELA law, what the petitioners sought in that case was to take down the entire CFPB. Their injury was that they were being investigated. But what they asked for as part of their remedy was to take down the entire CFPB. Now, they didn't get that. They didn't get that because the court found severability, not because they didn't have the right to ask for it or they didn't have standing to pursue the legal claims related to their injury. The reason I think we don't have examples of cases where we see this kind of separation of powers claim being adjudicated in the way that we're asking it to be adjudicated is because the facts of this case and some of the other cases you are dealing with right now are completely unprecedented and extraordinary. And I don't think that the speed and scope of the disregard of the law and the Constitution that the executive has been engaged in should reward the executive by removing judicial oversight. On the PI, whether it's abuse of discretion or not, as we argued in our brief, the district court made several legal errors in applying the PI standards, including insisting on some kind of certainty with respect to irreparable harm, including considering the executive's disagreement with congressional policy as a factor in the executive's favor, and by entirely failing to take into account the hundreds of thousands, if not millions, of deaths that were already taking place as a result of the shutdown of USAID. There are no further questions. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court now stands adjourned until Monday, April 27th at 9:30 a.m.